sir. I've just had a message from him. He's signing in now. He's just had a system crash.
Oh dear.
He says that he's just in the process of signing in at the moment.
That's fine. We'll wait. I mean, there's nothing. Well, we better wait for him to come before we cover anything.
I'm just checking with him, sir, whether or not it'd be sensible to adjourn for a few minutes, or whether or not he's sort of on the cusp of joining. Oh, there we go. Question.
Oh, great. Welcome, Mr. Turney. We've all had that problem, yes.
Morning, sir. Sorry, my the computer I was trying to connect on restarted just as I was.
Oh, yes, that trick. Yes, usually Microsoft updates that I get caught with that decide they want to start at 9:55. Yes, welcome everyone. There's nothing in particular I need to deal with from a housekeeping point of view this morning. I don't know whether you have, Mr. Simons. Was there anything?
I think there is actually, sir. There was an image, one of the AVR.
Oh yes.
Images that doesn't meet the ground in the right way, as Mr. Turney spotted yesterday, and they have accepted the error of their ways. They've updated it and resubmitted it. I don't know whether anyone's seen it. I wasn't copied into the email. I'm told that it was circulated.
Okay.
Thank you.
Good. Mr. Turney's got it. Now, I would just want to know whether or not you've got it then. Maybe not yet. I've
not seen it.
Not urgent. Maybe if we get to the end of the day and you've still not got it, sir, I'll ask for it to be resent.
Okay, I'll probably add that as an inquiry document. That's probably the easiest way to deal with that.
Yes, indeed. And the only other thing that's not at all in the least bit urgent, but I just thought I'll mention it just now, is to say that on the 14th of December, which was your sort of best day, if you like, for site visits, Tuesday the 14th, that suits the appellants team, that you won't have the benefit of Professor Taverner being there, but he's away all that week, but Mr. Froman can come, and I think probably most important, Mr. Henley can come as well. So that would be more than enough from our side. So I haven't checked with the others, but that would suit us.
Great. Okay. Well, we can come back to that either later today or next Tuesday when we will need to fix it. Mr. Philpott, did you have anything?
Just three very short points, sir. First of all, we have submitted this morning a note on the 5-year housing land supply.
Oh, right, okay.
That may not have reached you yet, but obviously, if when you've looked at it, you've got any queries, please do let us know, and we'll do our best to address them.
I'll do that. I'm grateful. Thank you.
Second point, I've seen this morning a slightly revised set of agreed conditions.
All right, okay.
I've only just started going through them, but it looks like the revisions are essentially uncontroversial points, striking out reference to things which are not relevant and matters of that sort.
Yes.
You'll need to have a set of those before we come to look at the conditions later. One other point on conditions. So unfortunately, Mr. Wilson's condition has deteriorated overnight, so he's not going to be able to join us for the condition session, which is unfortunate because he's the person most familiar with them. We will, I'm sure, do our best and field it without him, but you'll just have to forgive us if we're not as on top of the detail as he would have been.
Mm-hmm.
And then the third point, sir, Mr. Wilson mentioned in his evidence in chief an 18-metre separation distance in policy. It's in the SPD, which is CD 8.1, and it's at the bottom of page 19 when you look at that. So it's given window to window distance. That's, as I understand it, what he was referring to.
Okay, that's helpful, because I did find it in the core documents, but then looked at it and thought I'm going to have to traipse my way through all of this. But yeah, the page reference is very useful. About conditions, I found in the core documents a set which I thought would be the latest set, where the applicant had made some comments which were highlighted in red about several. Presumably, those are the comments that have been taken into account in the latest version.
I'm told, and we might be sort of getting confused over different versions. I'm told that the latest one that Mr. Philpott's referring to might actually be that one with the red ink that's attached to the Statement of Common Ground. Yeah. But if Mr. Philpott's got an even newer one, I don't think but I'll look into it. But I think that may be the version. That's the latest version I've seen. So if there's a yet newer one, I'll chase it this morning. Okay. Well, I'll keep an eye on it on my inbox. Mr. Turney, did you have anything this morning before I turn to you?
No, sir. I don't think so. No.
Thank you. In which case, then, unless there's anything else, the only thing I would say, sir, is in terms just to help behind the scenes, as it were, at Mr. Simon's end.
Just looking at the email I received this morning, there was an email from Miss Price at Gerald Eve to Mr. Wilson at 8:34 this morning, with a new clean list of conditions. It may be that the changes reflect the comments that were made earlier, but that's what I'm referring to. Thank you very much. I'll chase that down. Thanks a lot. Okay. Thank you, sir. That was the only thing.
Good. Well, if that set can be circulated so that we're all talking about the same thing when the time comes, I think that would be helpful. I'm going to hand over to Mr. Turney then.
Thanks, sir.
Carry on.
At the outset, I do hope Mr. Wilson's okay. I'm sorry to hear that he's unwell. And obviously, I'm grateful that both he and Mr. Jones, despite suffering, were able to attend yesterday.
Yes.
So I'm in a slightly strange position of examining myself in chief. I was going to take the format of actually just speaking rather than asking myself questions, if that's okay.
Yes, of course.
Obviously, you've got my proof, and you've got the appendices to it, which are the reports which I commissioned. And I'm not going to try to speak to those because I put them in really as written representations. Obviously, if there are points of clarification, I can try my best, but they're not my drafting. They're views of others that I've relied on. So the first part of my proof is really an introduction and a history of the site. And I just want to sort of pick those points up together, if I may, and just sort of speak to those points. My own position, I've lived in Fulham since 2008. I've lived on Fabian Road since 2015, when I moved here with a 7-month-old child, and there's now 3 of them. And obviously, when I moved here, the Edith Summerskill house was in place. It was derelict and had been for several years, and obviously I was aware of its dereliction, having lived nearby but less close for several years before that. I think the observation I'd make about the estate and the surrounding roads is that the estate is less part of the area than it should be because of its lack of permeability. There is a marked cycle route that runs through the estate, but it's a rather convoluted route. So to sort of take a direct route through the estate is a challenge and as a result, it's not well used as a route, and people, I think, would generally sort of go round the estate if they were walking north to south. I mean, I do walk through the estate, but I think many don't. I think people sort of stay away from it, and that is a negative, a significant negative in the area. In terms of what's happened with Clem Attlee Estate, I put some of the background into my proof, but I wanted to emphasise that it's been the victim of a rather unfortunate political battle, which is the real reason for why this has all taken so long. The previous Conservative administration was looking towards large-scale estate regeneration projects, and when they were voted out, the Labour administration moved away from that, and as a result, proposals came forward for some individual sites within the estates, and others, no proposals at all. It is an area which is crying out for regeneration and investment. And you won't hear me saying that the council should not be looking to develop the estate. My concern relates to the approach that's been taken to this particular site. And also, so I hope I've emphasised in my written evidence, but I really want to make it absolutely clear that there's a huge need for new housing to come forward, notwithstanding the existence of a housing land supply, and particularly affordable housing. That's true of Hammersmith and Fulham, as it's true of London. I want to be clear that I'm not going to say anything about reducing the weight to be given to that need. But what I want to really explain is that, as someone who works in the planning system, I've been convinced, and also as someone who takes pride in Fulham as a place. It's a very great place, not because of simply its sort of Victorian housing stock, but because of its diversity and its variety. We can't let the overwhelming need for new housing in London undermine our sense of direction as to good planning. And that's the sort of at the heart of why I've now expended a lot of time and energy on this, despite misgivings about opposing any scheme that was for housing. I mean, I'm throughout, I've questioned myself, we need new houses. Why should I oppose this? I've become the kind of NIMBY who I spend much of my career dealing with at inquiries on the other side of the fence. Just in terms of engagement and consultation and so on, and the actual process, I attended the first consultation event that I was aware of, which was in 2016. I was struck immediately by the scale of what was proposed, and voiced that concern to the people who were there. I was surprised that a building of that scale was proposed in the location. The subsequent consultation, it has been extremely poor. Yes, there were neighbour notification letters from the developer, from HFS. I won't go into it, but they were not planning consultation letters. They were presented always as new homes are coming, in bold. And of course, that's one way to see it, because it's true. And similarly, I don't know if they're still there, but there were signs for many years around the site saying new jobs are coming. And again, that's true, but it's not really consultation. And in fact, the local planning authority in 2017 didn't consult neighbours beyond a very close vicinity. So, for example, at my end of Fabian Road, I live towards the south of Fabian Road, we received no consultation notifications on the planning application. So when I heard about the application, I contacted Mr. Wilson. I spoke to Mr. Wilson on the phone. He was good enough to spare some time to speak to me, and he agreed that this was a complex application requiring careful consideration. I said to him that I'd want to speak on it at the planning committee, and the same point was made by my wife to the council. And sadly, the first thing we knew about the planning committee was being notified of the grant of planning permission. And then there's this very strange intervening 2 years where I wrote regularly, I think 7 or 8 times in total, to the council to say, look, I know you've resolved to grant planning permission, but the building is no longer there and the baseline has changed. And you've also adopted a plan which allocates the areas suitable for tall buildings, and that plan wasn't in place when you resolved to grant planning permission. And sadly, that was ignored. Very strange, but 2 years later, a planning permission was issued, and that's why very quickly I applied for judicial review, and everyone agreed that the permission should be quashed. There was then the fresh application, obviously, and that's what we're now concerned with. And in that context, I obtained expert advice, which you've seen, and I spoke at the planning committee. And then I wrote to the Secretary of State asking for the case to be called in. I know my call-in request is in the papers. I suspect the more persuasive one may have been from Greg Hands MP, who's the Minister of State, and he also requested a call-in. I think he might have been rather more influential than my humble letter. But there we are. That's how we get there. And I think I just want to emphasise it because, as I say, I've done this really with a heavy heart. I know the officers at Hammersmith and Fulham. I've worked with them and for them. I know the lawyers at Hammersmith and Fulham. I know people on all sides of this case. They're colleagues. They're people whose judgment I respect and value. And as I say, I don't want to be a person who opposes new housing, but it's clear to me that this is a wholly inappropriate proposal. And that's what has led me to do something which in other circumstances I would have no enthusiasm whatsoever for doing. So I just want to touch then, just taking it from that background on the need for the scheme, because I think that's the logical starting point, and then I'll come on to sort of take you through the sections of my proof and just draw out a few particular points. In terms of a need for a scheme of this scale, I just want to take a few points. First of all, the task, of course, is to optimise the use of brownfield sites, including small sites. Although in terms of small sites, I think really that's talking about not missing opportunities in small sites, rather than saying, oh look, there's a small site, let's get as many houses as we can on it. It's about not missing opportunities. But optimizing, as you know, sir, is not maximizing, and a blind pursuit of maximization has never been supported in policy. And of course, it leads to only one conclusion, that you would keep in London building upwards until you had met the vast unmet housing need. And that's no one's policy and never has been. In terms of the quantum for this site, you've heard my questions to the witnesses. I don't think there's a lot more to say on it. In 2017, the scheme was presented to committee as being needed to be of this scale for A, viability reasons, and B, to accommodate what was being lost at Watermeadow Court. And Mr. Henderson said that I was being misleading in saying that was the reason, but if I was misled, I was misled, but so was the planning committee. The resolution to grant the initial decision, and indeed the mayoral consideration of the first application, was plainly and expressly on that basis. So if there's misleading, then it was done by others and not by me. In terms of the need, I just sort of emphasise that the need for social housing and affordable housing is of course in a sense generic, because this is a need which is spread across the borough and indeed London. It is possible, of course, to meet that need in various different ways. You've heard that there have been a number of demolitions in the area. And I think it's a point that needs to be just borne in mind, that there are lots of people in temporary accommodation in the area in Fulham. But remember that Edith Summerskill House went, Watermeadow Court went, Hartop and Lannoy, which are the two towers just up Dawes Road, have both recently been decanted. So the fact that people have been displaced obviously is pretty influential in that. I mean, between that's around 200 units, I think, of accommodation which have just been demolished without replacement social housing. So turning then to the site, the key point I want to emphasise to you, sir, is that you haven't seen any assessment of the capacity of this site. We were told by Mr. Henley that all proposals that he considered were for at least 110 units. And the problem I think we've had here, and I think everyone's been led down the garden path a bit, is that the site has been taken in isolation without any comprehensive view, and then its planning history has led to an assumption that because an unsuccessful tall building was previously on the site, that necessarily must be the type of building that comes forward in the future. And that assumption has underpinned every bit of thinking. And I think, the striking point is the acceptance by the architect and by the planning officers that, having agreed that the baseline had fundamentally changed, this was no longer a site with a tall building on it. They then essentially pursued the tall building that was going to be a replacement, despite the fact that that was no longer the proper basis on which to assess the approach to the site. And that, to me, is the point where the sort of absurdity of the position we find ourselves in really heightens. And I do think it's absurd. And you make your own judgment, and I've made my inexpert judgment, and others have made theirs. But when you come to St. Thomas's Way, I just ask you to just look at that site, standing back, and just consider, is that an appropriate site for a tall building? Because I think applying a neutral gaze, as I know you will, my own view is you'll very quickly come to the conclusion that it's not a suitable site for a tall building, for all the reasons that I've tried to articulate. So far as there are capacity studies, they're in the plan making process, and the evidence base that we've seen is fairly limited. But you've got CD 14.11, which I've been to. The reasoning is clear, although the sort of underlying studies are not there. But the reasoning is clear as to why the capacity in the borough for tall buildings is constrained. But Hammersmith and Fulham is a borough which has allocated areas for tall buildings, and they're large areas, South Fulham, Riverside, particularly the opportunity area at Earl's Court, particularly White City, and particularly Hammersmith Town Centre, which is now delivering a lot of houses. Those are areas which have been identified. This isn't an authority which perhaps might be true of others, where they're sort of sitting on their hands and saying, we don't like tall buildings. Just then on sort of other ways to approach the site before I come on to some more points of detail. No one has looked at other opportunities for this site, about other ways that it could be developed in an acceptable way. We've had no evidence at all about anything other than really minor design changes. That, as Mr. Simons emphasised, there is material in the design and access statement that explains, for example, treatment of materials and changes to the floor plates and so on. But no, everyone has always assumed it's a 20-storey plus building, and no one's really grappled with anything other than that. So I just turn then to sort of sections 3 and 4 of my proof after that introduction, and I think start with this, please, that townscape, character and appearance. I want to emphasise the scale of the building when viewed from the surrounding streets. I think the suggestion that the surrounding residential streets are, I think it was put as thoroughfares yesterday, and a sort of kinetic view. Of course, they are in part thoroughfares, but I don't think residential streets really should be treated in that way. A residential street obviously is a collection of homes. It's where people live. People go in and out of their houses and pop around to see their neighbours and, you know, put the kids into the car and so on. They're not just thoroughfares. They're part of how we live, particularly on in place urban environments. There's then this sort of suggestion in townscape, character and appearance terms that somehow this building becomes an entrance to the estate, a waymarker, and there's repeated role, and I want to deal with this at the same time, to the base of the building in helping to sit the building in its surroundings. And I have to say that I think that's just a simple misconception. The base of the building is barely to be seen apart from in very close views, and that's because of the fact it's been landed onto a small site with very little space around it. It's not seen in the approaches from the south. It's not really seen in general approaches from the west, save for when you're on St. Thomas's Way itself. And in fact, I think if you look at the corrected AVR 10, the loss of the setback from the previous building means that the building is actually less well accommodated in the street view. It becomes quite a sharp and very present building, and you're drawn immediately upwards to the height of the building, and there's no moderation from the ground floor treatment. And looking at the base as well from the estate itself, it's very few views that you will actually see the base, and that's because of this really close-knit character around where the site lies. Particularly from the east, there's a very tight pattern of buildings, and whether that's good or bad, that is what is there and how people will see it. You won't get to the base until you're basically walking out of the estate. And that means any contribution of the base to softening of scale or to legibility is extremely limited. And I emphasised in my proof a point about mediating between the surrounding areas and the tall building. The London plan expressly looks for a transition of scale. And I think, as I took Professor Taverner to, that sort of, I have to say it's by coincidence, there is a transition of scale when the estate is viewed from the north looking southwards, but it's a transition of scale to a cliff edge. And the cliff edge is the proposed building. And from the south, you face that cliff. And the transition, if it is visible at all, is of buildings dropping away behind it. So I don't say much about architecture. You're the expert, sir, and I leave it to you. And I recognise that in terms of the detailing of this building, there are clearly some impressive elements. I think the floor plate itself is well conceived, and I acknowledge that. But the design rationale, in my view, starts to expose the problems I've described. It's not a place for a civic building. The sort of soaring arches, which are the height of the surrounding buildings, the arches are the height of the surrounding buildings, that they aggrandize it. And this is not a place for a building to take that form. I perfectly accept that housing in some locations may adopt that grand civic quality, and that the housing itself can have an important role in placemaking of urban areas, of town centres. But this is just the wrong location for that treatment. And to the extent that it is a good building, and there are bits of it which I think are very good, it's a good building in the wrong place. And I think Mr. Henley's evidence showed that he had thought carefully about the building, but I think perhaps less care has been taken generally in thinking about whether it's the right place for it. The other point I just mentioned is in terms of the crown of the building. I'm unclear as to what it brings, but that's something I firmly leave to you, so you're more expert than me on that matter. I just want to pick up then just one more point, which is the sort of treatment of the civic of the urban realm immediately within the site. And so I don't know if you could pick up AVR 27 and 28, which is in RT3. I think those two perhaps show best the sort of immediate treatment. And if one looks at AVR 27, Mr. Jones was sort of eventually willing to accept this was a modest open space. I would go further, and I would say for a building of this scale, this is a vanishingly small contribution to urban realm. It is close to being, frankly, nothing more than an extended pavement. And you see that, I think, just clearly in that image at AVR 27, the sort of handful of benches which could perhaps accommodate maybe 20 of the residents of the building, of which there will be several hundred. And that immediately to me says this is a building which hasn't been thought about properly in terms of its capacity, the capacity of the site. And it's a sort of a warning sign, and I'll pick up some more warning signs about overdevelopment shortly. In terms of the arcade, I recognise that will be a more pleasant route into the estate than it currently is, but it's not actually a more spacious route than what was there before the site was hoarded, where there was access both sides of Edith Summerskill house until it was hoarded for demolition, the extended hoarding for demolition. And it's the hoarding of the site that lost, in particular, that permeability. You had to cross the car park before, and obviously that in itself wasn't ideal, but it's the hoarding of the site that has broken the permeability from the south most profoundly. So I'll leave townscape points there. You've got my evidence and the expert's evidence I rely on. I'm going to just move on to heritage, if I may, which I deal with in section 4 of my proof. This is a building which cannot be accommodated on the site without harm to both the grade 2-star listed church and the conservation area. I don't propose to go through them. They've been addressed in detail, and I think so now it's probably the time for you to go and form your own view. So I'll leave that with the written evidence. I just want to emphasise Walham Green, and I know you'll have to make a decision about that and whether there is harm there. I think these impacts have been misunderstood by Mr. Jones and by Mr. Froneman. That area is a very special part of Fulham. It's enjoyed by many people, and it gives what some conservation areas lack. It actually gives a really clear image of the past and of the history of Fulham. And I would say there's a lot of sort of time depth that you appreciate in that conservation area, which you might not get in lots of other places. I don't agree with the view expressed that the buildings around what was agreed to be sort of the core of St. John's Church are detractors. I don't think they are. I think, you know, we could debate that, but my own view is they're not detractors and that they have maintained the integrity of that part of the conservation area. The Broadway, Fulham Broadway, does have more of a town centre feel with larger modern buildings, but not so that core around St. John's Church. And finally, on that point, Mr. Froneman was very keen in his rebuttal to emphasise a difference between me and Mr. Griffiths on the level of harm. And I accept that this is not the upper end of less than substantial harm. And I apologise for that. That was part of my proof that was carried over from my statement of case and preceded the advice that I received from Mr. Griffiths on that particular point about the level of harm to the Walham Green conservation area, or at least preceded me understanding it properly. So I don't ask you to find upper end of less than substantial harm. It falls lower on the spectrum, and I leave it to you as to precisely how to describe that. So that's all I want to say about heritage. Section 5 of my proof sort of deals with other impacts. I think the theme that I want to pick up is really that my sense is that sort of development control impacts can be a signal as to overdevelopment, and really that's what the optimization is about, because you could keep going and keep going in terms of building upwards, but are those impacts, those development control impacts, acceptable is a good measure. And I appreciate that many objections refer to parking as a development control impact. Now, there will be parking issues that arise from the development, but I don't say that those are a reason to prevent development at this scale. I think in part it's really a misunderstanding as to how sort of the impacts of a building like this play out. And I understand it, why neighbours say parking, because that's a sort of tangible thing that people can put their finger on. And people, I think, struggle to articulate how changes in character and overdevelopment in fact play out. My own view is that the core impacts are the failure to accommodate new residents in terms of outdoor amenity and play space, and the clear environmental impacts of wind, daylight, sunlight, overshadowing, and the lack of any attempt to accommodate the building by doing anything meaningful beyond the red line of the site. So I'll just deal with play space first. I think, you know, I know the area and its play areas. I have 3 young children, and I use play areas throughout Fulham and have done for several years now. I understand how they're used, but I don't claim any particular expertise. The ACOM assessment that everyone relies on, applicant, planning authority, and indeed the GLA, as people were keen to emphasise, they said it was acceptable, is illogical, and I'm afraid it is illogical. It lacks any logic. It works through, and I've shown it to the inquiry already. It's in the back of the planning statement, but it works through identifying a yield, and from that a need by reference to both the area required and the distance from the development. So so far so good, but at that point it jumps to a conclusion that the impact is accommodated, and it's simply not, because as soon as we have to look off site, and everyone says, well, you must look off site. So we look off site and we say, what's there? There is a play area suitable for under fives within 100 meters, tick. It is quantitatively half the size of what's required for the development, cross, that fails. So it's not big enough to accommodate the development. It's already used by others. So I don't know how many people use it or frequency of use. I've seen people using it, but I've also seen it on many occasions not being used. But in a sense, it doesn't much matter, because in any event, this isn't a case where there's 400 square meters of play area and the question is it at capacity already? It's simply not sufficient to accommodate the development. So this is not a case where you can report that the need is met off-site, and although that's not ideal under policy, it's acceptable. It demonstrably is not met off-site. And this is a development. I think we need to be very clear on this. This is a development that will accommodate families. The calculated child yield of 78 applies the GLA metric, and I don't dispute the calculation. But let's just think about this carefully. We're told of a significant housing need and of a significant number of families in housing need. And families will be given priority. So if new social housing becomes available, it will accommodate families. And I think a point, sir, that I'm sure you'll appreciate, but I want to emphasize, is that a one-bedroom flat social housing, a one-bedroom flat with a separate living area, is family accommodation, because it is not overcrowded if it contains a couple and 2 children under the age of 10. That is not overcrowded to accommodate that number of people. So when Hammersmith and Fulham is looking to allocate housing, and there's a family of 2 adults and 2 small children, or 1 small child, then a one-bedroom flat would be considered suitable. And I think that's a really crucial point, that this is a development that will be occupied by families, and the failure to accommodate children by way of play space, I think is very surprising. And the ACOM analysis that just asserts that those needs are met, it should be given no weight here. And unfortunately, it's become the mantra of everyone in the process, and no one's really interrogated it. And so you heard my questions to Mr. Henderson, and you saw his pause, and no one has really thought about this. So in terms of the contribution that's made, I've dealt with this in my evidence. It's a point I had to pursue, because there was no answer as to how, in fact, it was being spent until very, very recently. And you've seen the update, and so be it. But what we do know about that is that the money is going into a general pot. It can be used for play space, it can be used for public realm. It will be decided upon by existing residents and existing operators of the existing buildings on the estate. And I think, sir, it's obvious that their concerns may be different to those of the future occupiers who will come there and find the site as it is. And we simply don't know whether that £50,000 will be spent on play space at all, and if it is, whether it's play space close to the proposed development or not. And for a building of this scale and the number of units and the poor quality of the current public realm, my view is that what you see is a miserly contribution, and it's one that clearly will not meet the needs of the residents. So on that point, I think the only rational conclusion is a breach of policy S4 of the London plan and of the place-based policy of the local plan, which is OS3. I think that's the only rational conclusion that you can reach. So daylight, sunlight is the next point. I think you have my point on this. The finding of acceptability in light of breaches of BRE guidelines in numerous occasions is dependent on this analysis of context that's carried out by the applicant. And that context study is based around the Emperor State Building and the Ibis Hotel at Earl's Court. So in that context, yes, daylight and sunlight have been compromised by existing tall buildings. But in my view, that's not a proper way to assess the impact of a new tall building. And indeed, it's quite dangerous, because if you assume that the context is a tall building somewhere else, then you would always come to the conclusion that it's an acceptable impact. The breaches in question are recorded in the officer's report on the application and in that assessment. They are many and extensive, and in my view, that should be recorded as an adverse impact, but also a breach of the relevant parts of the tall buildings policies. So in terms of wind effects, I don't know. I don't think we've actually been into the document really. There's an extract from part of it in Mr. Henley's evidence. It's CD 1.19, and I don't know. So if you could just briefly turn it up, just so the points that I've made are not sort of seen as being entirely in the abstract. You'll be familiar with the relevant criteria and the Lawson comfort criteria and the methodology and so on, and of course none of that's disputed. There are a couple of locations where particular strong wind effects were noted, and those are of course safety issues, and mitigation is proposed, and I don't dispute that mitigation has been effective to remove those safety issues in the two locations identified. But if one goes to the figures, there's at page 29 of the PDF, this is into the appendices, there's the pedestrian wind comfort conditions at ground level, and that's the first image is called configuration 1, existing site with existing buildings, windiest season. So that's the sort of windiest season baseline. And what you see is a combination of sitting and standing as being the relevant Lawson comfort criteria. And the sitting areas include the areas around the play space and the existing open space immediately to the northeast of the site, northwest of the site, sorry. And you can see those on that image. And then the next one is the summer season, where everything apart from one is a sort of sitting condition. And then if you go forward and let's assume the mitigation, so you skip over the existing surrounding buildings, configuration 1 and 2, and then move to page 35 of the PDF, which is proposed development with surrounding buildings and landscaping, so assuming the mitigation is in place. And what you see is that in the areas which previously were met the sitting or standing criteria, particularly in the amenity areas to the northeast of the site, that they shift to from sitting to standing, or from standing to strolling. In other words, the wind conditions change such that it would not be comfortable to sit in the locations that were previously identified as comfortable to sit. And that's the play area in particular that I'm concerned about, because we're relying on a very small amount of play space, and effectively its condition is being undermined by the building itself. There are also changes on the access route to the east of the site. So points, you can see points 21 and 33 and point 10. The only point I make there is, whilst they meet the standing or strolling criterion, that is the designated cycle route. So the change in wind conditions there is on that designated access through the site. And the final point I make is look at the conditions in the areas that are identified as the new public realm immediately around the site within the red line. And those are areas which are not suitable for sitting in that season. And indeed, on the next plan, you see parts are not suitable for sitting even in the summer. You see the standing points which take up much of the new limited amenity area. So that's all I wanted to say about impacts, and then just briefly section 6 of my proof and the policy. I'll deal with this obviously to an extent in closing submissions, and I've set it out in my proof of evidence. The point I wanted to explain, which I think is probably more evidence than submission, is that I appreciate that there may be judgments to be made about whether you could comply with policy D9, and depending on the Hillingdon case, whether that's relevant to assessing the extent of development plan compliance as a whole. But I say that even if that approach is right, even if the mayor's approach was right in Hillingdon to say, well, development plan as a whole complied with, notwithstanding breach of locational policy, I don't think that finding works here. And I'd say that for the following sort of judgmental reasons, as opposed to sort of submissions on the wording. This is a borough which has assessed capacity for tall buildings. It has carefully articulated a policy for them, and its own plan contains a presumption against tall buildings outside of 4 identified areas. So this isn't a case where we're left waiting to see how and where tall buildings may be supported in the plan. In other words, it's not a case where there's a sort of vacuum between the London plan thrust of boroughs must identify and the boroughs doing that identification. Here it's crystal clear. It's crystal clear what the borough wants and what the borough's consulted upon. We've got an up-to-date plan that does exactly what it's required to do. And I've set out in paragraph 6.4 of my proof that passage from the supporting text, which I think provides the answer here as to why this borough says tall buildings should be in those 4 locations and not elsewhere. I've set out my analysis on those policy tests at 6 throughout section 6. There's a missing word at 6.9.4 of my proof. It should say nothing at the end of that sentence. And I've touched in asking questions on the heritage parts of policy D9. I just emphasise that there's a policy requirement there to consider alternatives. And then section 7 of my proof is benefits. I think I've already addressed this, but again, I'm keen to emphasise that it's not overlooked, and my view on that is not overlooked. I think the real care that's needed in a case like this is assuming that a weighty benefit can start to sweep away other matters. And if that was so, we'd simply maximise in every site, particularly for affordable housing. That's not what policy requires, and nor should it be. And again, so I'll just finish on this really, that looking at that need and the benefit that's delivered from this scheme, I just encourage really a sort of stand back and look approach. It's a highly constrained site. It's a tiny site in terms of the estate as a whole, and in terms of other sites that you've already heard about, Watermeadow Court, the Hartop and Lannoy Point developments. And in each of those instances, what is being pursued is a much lower form of development. The need in question is precisely the same need that is relied on here by the applicant for this site. The need's no different on St Thomas's Way than it is at Dawes Road on Hartop and Lannoy, or indeed in South Fulham Riverside at Watermeadow Court. And that's why we need to be careful about saying that the weighty benefits that can be obtained from building many affordable homes can start to outweigh these impacts, because it is a typology and it is a level of impact which is not acceptable in this location. So that was all I wanted to say on in terms of my evidence. I hope I've taken it through in a logical order, and you'll see how I've set it out in more detail in my brief.
Thank you, Mr. Turney. An unusual situation, but I think, Mr. Simons, I need to come to you first.
It's a first for me. It's a very unusual. I've never been asked to ask questions of a colleague, a member of Chambers before, so
right. I'm not sure that's true. I've been to plenty of Chambers meetings.
That's true. That is true. Well, Mr. Turney, good morning. I'm not going to, for obvious reasons, I hope obvious to you, Inspector, not going to go over questions of detail on things like heritage or townscape. Mr. Turney didn't in his chief either, and so I think for most of those, the big issues, if you like, they are where we are. You've got Mr. Turney's views, of course, and those of his consultants. You've got the views of our team, as Mr. Turney said, and he's quite right, of course. Now's the time. It's site visit time for you to go out and form your own views. So really, I've only got a couple of very short questions then, and they're really more about clarification, so that to help me when it comes to trying to put together closing submissions. So number one on the list is alternatives. Lots of questions on this from you, Mr. Turney, from us as well, but in re-examination and all the rest of it. You mentioned in your evidence in chief the points about that I'd taken, I think, Mr. Henderson to in re-examination, points about the DAS and changes to things like facade treatments and all the rest of it. So we know that's sort of one sort of category, if you like, of alternatives, tinkering, design, optioneering, and all the rest of it. There's another category though, which of course is alternative sites, and that's just the thing I wanted to understand so that I could, prepare, if you like, in closing. Is it your case that the Secretary of State should, if you like, weigh against this scheme, weigh against permission, a failure to consider alternative sites?
Yes. Yeah.
In that case, do you have a couple of cases? I'm not. It's very unusual to cross-examine on the law, and I won't. But it's not on the law. It's really on the facts.
Yeah.
On the facts of cases, there's the Stonehenge case that you put in the other day, and there's also, let me just get up it's the Trust House Forte case also that I put in. Well, oh, did you? I don't know whether that either of I should have.
No,
checked.
I was sent it, but I didn't expect to deal with it today. I thought it was going to be a submission.
No, it will be.
No, I've got it. Yeah, I'm familiar with it.
Certainly will. You're familiar with it. If you get it, and there's Stonehenge as well. If we just, I don't know, we won't be long on them, but if you just have them inspector somewhere vaguely accessible. Okay, so we agree. Just take a step back. We agree that this site should urgently be developed for affordable housing.
Yes, we agree that. Yeah.
We agree that a scheme, in order to achieve that outcome, that i.e. the development of the site for affordable housing, one way or another is going to have to respond to the London plan's requirement to optimise the site's capacity.
Yes.
And we know that over the coming years, in this borough, there's a need not for hundreds but for thousands of homes, and indeed half of those at the strategic level are supposed to be affordable homes.
Yes.
Okay. We know that need, if you like, for affordable homes, such as its scale, it will never be met by a single scheme, or indeed by a couple of schemes.
That's right. Do you mean the affordable, the existing identified affordable housing need?
Exactly so. Yeah.
Well, it would require, to meet that level of need over any particular period, it's highly likely to require multiple sites.
Yeah.
I don't want to be difficult about it, Ms. Simons, but I think, there are very large sites in the borough which are coming forward.
Sure.
And depending on the way in which they were promoted, they could meet on an annual basis or on a multiple year basis the established need through single sites. But I'm thinking there about the major opportunity area at Earls Court, and the precise form of that development obviously has varied over the years, but at one stage it was contemplated that it would include substantial redevelopment of the Gibbs Green and West Kensington estates, which would have led to a substantial affordable provision. I'm
with you. I mean, the London plan target, if it were to be met, would require the delivery of I think it's over 8,000 affordable homes over the next 10 years in Hammersmith. And
you can't. A single site is highly unlikely to deliver 8,000 affordable homes.
Yeah.
But okay. Whether a single site could meet the annualised need or the need over 3 or 4 years, I don't know. But I don't think we're miles apart on this proposition.
No, good. Now, so we've got. I think we agree at least that meeting the need as a whole, that the need that's set out in the plan, the existing need, highly likely to require multiple sites. Now, you put in the Stonehenge case, which is one I anticipate that you'll come back to in your closings. And as I say, or to state what I hope is obvious, it's not a case of going back and forth on legal propositions, although we could have a good old laugh doing that, I'm sure. Now, in the Stonehenge case, though, with which I expect, and I'll just check, Inspector, do you know anything about this case at all in terms of what the background is to it or anything like that?
Well, it was obviously something of interest to me. I mean, yes. I didn't. There were a number of colleagues on the on the panel who I know rather well. Not that we've discussed it in any detail, but I did keenly anticipate the publication of the judgment to see what would happen.
Yeah,
because the avenue of challenge was one which is, it's a question which has been in the mind of practitioners in quite a lot of cases around about how do you deal with that question. So I did view the judgment I did read the judgment very carefully.
That was it.
So I am relatively familiar with it from an inspector's point of view, not from a lawyer's point of view, obviously.
No, well, you're probably more familiar than me, but that was all really. So just checking to see whether or not you'd read it or even
yes,
you knew what it was about. But to sort of cut to the chase, Mr. Turney, there was a need, wasn't there, that had been recognised for several years to upgrade this road. I think it's the A303 one way or another.
Yeah, I mean, if on the facts, I acted for Highways England in the examination, so I'm pretty close to them. But that's right. The underlying need was for capacity on the A303, which has been established as an issue for decades. If you've driven through the A303 and through Wiltshire, as I'm sure the inspector has, on a summer, well, you don't drive. You'd be better leaving your car, keeping another car the other side of Amesbury and walking.
I think I've had personal experience of that painful A303. There were many potential ways of upgrading the road, but the point there is that a single scheme was being promoted in order to do it.
Yes.
And that scheme, it might have, if you like, gone one route or another. It might have had a tunnel here or a tunnel there. But the point is that there were never going to be multiple schemes coming forward in order to give us many happy ways to get round Stonehenge. There was only ever going to be one road improvement scheme to upgrade the A303.
But for the purposes of this judgment, that's the underlying analysis. Again, I'm slightly trapped because having dealt with the examination, there were alternatives by way of other capacity interventions, but in terms of improving the A303, yes, it was the only scheme was a road scheme to improve the A303 on some alignment.
Thank you. Now, that's just the sort of the background, if you like, to the A303 case. The judgment refers to a number of other cases. One of them, at page 63 of the judgment on para 273, is a case called Langley Park.
Yeah.
And in that case, I don't know, again, as inspector, this is you may or may not be familiar with it, but it's one of these quite well-trodden cases all about alternatives. Langley Park 273, that was a case about a new school in Bromley that was proposed in Bromley. And it was, as the court explains at 273, what that case was about was an example of where you had alternative options within the same area of land for the school to be located on.
Yeah. It's a MOL MOL rather than Greenbelt, but basically, could you reduce the impact of the school building on the openness by proposing a building in a different configuration?
Exactly so. So could it go somewhere else, if you like, within the same application site?
Yeah.
But to state again what might be obvious, but it might bear repeating, there was only ever going to be one school. There was no suggestion that there be. I mean, we can deal with it maybe in submissions, but it's clear from that case, which, as you may remember, that the suggestion was, where do we put this new school, this new replacement school? It was the Langley Park, I think, the boys' school. There was already a girls' school. So where does the boys' schools go? It was never a question of, well, let's build two or more. There was only ever.
I had in mind that it was the existing boys' school site being improved.
I think it's a replacement school.
Was it an entirely new school? Okay.
Fair enough.
But look, I haven't checked the facts.
No.
Let's assume you're right for the purpose of your questions.
No, that's fine. Then let's turn then, if you've got it, and if you haven't got it, that's fine, to the Trust House Forte Hotels.
Yeah, I can guess it.
That would be great if you could.
Yeah. Yeah.
And you'll be familiar, and the inspector will too, with those oft trotted out principles of Mr. Justice Simon Brown, as he was back then. And on the report, on the PDF that I pinged around to everyone, they start at the top of page 7 of the PDF. But depending on, Mr. Turney, where you've got it, it may be that it's sort of in a different place. But there's the 6 principles.
Yeah.
Have you got them?
I've got them, yeah.
Very grateful. Inspector, do you know where I'm looking? Good, excellent. Okay, we don't need to go through. We can come back to all this stuff in closings. But the third one sets out examples of instances where material sites might be alternative sites might be material for the decision maker. Instances of this case are developments where the national or regional importance, like airports, coal mining, petrochemical plants, etc., etc. There's a reference to a judgment from Mr. Justice Oliver, a few lines down, in a case called Greater London Council. The London Docklands Development Corporation suggests a helpful, although expressly not exhaustive, approach to the problem of determining whether consideration of alternative sites is material. And then we get a sort of 4-point list from Mr. Justice Oliver. Do you see? Do you see where I'm at, Mr. Turney?
His 4-point list.
The 4-point list. It starts: comparability was appropriate generally to cases having the following characteristics. And
sorry, I've lost that reference. Can you just give me the page? Which page are you on again? Sorry, I'm being slow.
So on the PDF I sent around, I'm on page 7, and I'm sorry, I don't know whether you've got that version.
Yeah, no, sorry, sorry, it's
Brilliant.
The middle of that page. Yeah,
yeah. So it's sort of the indenting could maybe be a little bit more clear. But what's happening?
I've got it. The problem is I've got it open in my webmail, so I'm kind of I haven't downloaded it.
Not at all. Not at all. So what's happening is that Mr. Justice Simon Brown is setting out another judgment from Mr. Justice Oliver, and we're told that comparability was appropriate generally to cases having the following characteristics, and then there are 4 which are set out. First, the presence of a clear public convenience or advantage in the proposal under consideration. Secondly, the existence of inevitable adverse effects. Thirdly, the existence of an alternative site for the same project which would not have those effects. And fourthly, this is the thing I wanted to ask you about, really. Fourthly, a situation in which there could only be one permission granted for such development, or at least only a very limited number of permissions. And then Mr. Justice Simon Brown goes on at paragraph 4 or 4th of his principles. In contrast to the situations above, are cases where development permissions being sought for dwelling houses, and goes on, offices, etc. Do you see?
Yeah.
Now, here, the reason I've gone through that interesting journey through the cases is that we're to be contrasted here with a case like Langley Park or with a case like Stonehenge, because even if, let's say, another site emerges for 133 plus homes, or indeed many, many more homes, there would still, wouldn't there, be a need in this borough for many, many more affordable homes in addition to that alternative site?
Yes.
And there would still, wouldn't there, be the need to optimise the capacity of this site in accordance with the London plan?
Yeah, absolutely. But I think you're sort of misunderstanding what I mean. It's probably my fault for not properly articulating it, but by what I mean about consideration of alternative sites. So
right.
The position is that we have, and dependent in part on how the inspector lands on these issues, but we have in any event harms identified. And what the applicant's case is that, look, you're always going to need a lot of affordable housing, a lot of social housing, and that justifies sort of ploughing on, regardless of those adverse impacts, those harms. And the point then, in my view, comes up as to whether that in fact is right, because you may be able to avoid those harms by looking to other sites for accommodating some of the quantum of the development. And I think that's particularly so. And I take the examples that are given here, but I don't think it can be exhaustive in considering what's the material consideration. I think that's particularly so when you're looking at something where effectively you've got the local authority being responsible for the delivery of social housing in particular, and having control, albeit potentially under some different arrangements, but control over a number of sites which can accommodate social housing. And then it's saying we need to have 133 units in this location, and that's the proposition which I think is the first one that I dispute, because you would need to show that there wasn't capacity in other sites. And if you take, for instance, Mr. Simons, the Hartop and Lannoy sites, those are, I think, were 10 or 12-story buildings being demolished, and a lower form of development is being contemplated there. Well, is that the right solution in terms of the balance between these two sites? Watermeadow Court, low-rise social housing, but a much larger size. I think it's 4 times the size of, perhaps more than that, of the Edith Summerskill site, in a designated area for tall buildings. In other words, an area where in principle they're acceptable. Then one starts to have to think about these issues. And my point really to the inspector is he's got nothing on that. He's got nothing on that. Your clients haven't attempted to interrogate whether in the holdings of the council there are better locations. And really, HFS is created in the dark. We don't know much about the commercial arrangement, but what we do know is that sort of sites have been pooled into HFS. They've been pooled into this developer, and that has really determined that a quantum of development is delivered at a particular site. And to my mind, that begs the question as to whether in planning terms that's appropriate. And the other point that I think is important is that when you're looking at Trust House Forte, you're not looking at a policy test for alternatives. When you're looking at Stonehenge, there is a policy test for alternatives there, and that was found to be met. And the issue really was whether beneath that, alternatives which were a material consideration in light of the harm to the designated heritage asset had been properly considered. And the promoter was found to have stopped at considering the alternatives that were required for purposes of national policy state compliance. So in both those instances, you're looking at an alternatives consideration that is sort of created as a matter of the law of material planning considerations. Now, I'd say that's triggered here, but your proposition is that I think perhaps that it's not. But the real point here is that there's a policy requirement. There's a policy requirement to consider alternatives, which is not constrained.
Yeah, indeed there is, which is something that I asked Mr. Henderson about in my re-examination. Your point about the potential for better locations, that was how you put it in your answer to me just now. Better locations. This is why, and it might be in a sense that there is misunderstanding on my part, and that our cases are passing a bit like ships in the night, because there may be a raft of different locations all over Hammersmith and Fulham where we need to be fulfilling the objectives in the local plan and in the London plan of maximising the delivery of affordable housing. But even if there are, and indeed there are other locations, it doesn't obviate the requirement to optimise the capacity of a site like this. Even if you do hundreds and hundreds and hundreds and hundreds and hundreds of homes elsewhere, we still come back to the site of Edith Summerskill House, and there's still a policy requirement one way or the other to optimise its capacity.
I completely agree. The policy to optimise is unaffected. But again, I think really my sense is that the applicant has misunderstood what that means, because optimization is not maximization. Yeah. That's a very important starting point, and I know that Mr. Henderson got that. But the difficulty is that you have to read the development plan as a whole. And when you do that, particularly the local plan, you understand what optimization means in the context of Hammersmith and Fulham. And optimization means having regard to a pretty distinctive character of the borough, but also noting those areas where tall buildings in particular can be accommodated. Now, in understanding what is meant by optimization at this site, one of the key things that you have to have in mind is this site is not identified as appropriate for a tall building. So you've got to read it as a whole. And the problem is, if you don't, then you say, right, the starting point for every single site in the borough would be a tall building. And then you test the acceptability of a tall building on that site. That would be your starting point. Now, that, in my view, is not what the London plan or the local plan says. It says you don't start with a tall building. You don't start with a tall building because it's not in a suitable location. If you're in the opportunity area and you're looking to optimize a site in the opportunity area at Earl's Court or in Hammersmith Town Centre, I think you probably would start with a tall building to see whether that optimizes, because that is policy compliant. So the development plan as a whole gives a very clear signal as to what optimization means on St. Thomas's Way. It gives a very clear signal. And unfortunately, the developer has not listened to that signal, and it has started with a presumption that it's hundreds of units. And that's why I take a sort of stand back and look approach, and that's the approach that I'm asking the inspector to take, which is to come to the site and say, optimization here, does that mean a tall building? Because I think, and you would have seen the site, Mr. Simons, it doesn't cry out tall building.
I know that's your view.
But, you know, I can't ask you questions.
No, of course. Then I wonder, though, whether the alternative sites analysis, so that prism, if you like, of looking at that way of looking at it, really helps us or takes it further, because the fundamental sort of the gravamen of your position is that this scheme overdevelops the site. It fails to optimize. It fails to optimize by attempting to overdevelop. That's your. I'm not doing it justice. You've just expressed it, but that's the sort of nugget of where you go. You say optimizing on this site would result in something lesser, if you like, fewer units, lower height. Now the inspector may agree with you, and the Secretary of State may agree with you in due course, in which case I don't think, you know, this application is going to succeed. If, however, the inspector decides that our scheme does successfully optimise within the meaning of the local plan, and in particular, I suppose, the London plan, if the inspector decides that a scheme of 133 homes on this site does equal optimise within the meaning of the London plan, then the alternative sites analysis doesn't really take us anywhere, does it? Because you could equally go off and optimize a number of other sites, you know, across Fulham, and you should. I mean, you know, but we'd still come back to the requirement to optimize this site, whatever that might mean.
No, I don't think that's right. I think you've taken the questions in the wrong order. So the reason that policy, I'm thinking of D9 here, the reason that policy says look to alternatives is that what it's doing is it's saying identify carefully with regard to constraints where to put tall buildings, and then it says once you've done that, you need to go through a series of hurdles, and if one of those hurdles is failed, namely harmed heritage assets, then you actually need to look to alternatives, because what it's trying to do is find a situation where you can deliver tall buildings in designated areas where the capacity is being tested, and do so without harming heritage assets. That's what it's trying to do. So the sequence that you go through is, am I in the right location? If I am, do I meet these criteria? And if I trip over on the heritage test, then I need to carry out an alternatives analysis, because I need to show that there are no alternatives to building this development or causing this harm being the important point. And that is a sort of a logical sequence. The difficulty with an application such as this, and kind of the heart of the policy dispute, is that I say you fall flat on your face when you get to the start of D9 and fail. And then, of course, you bring in this sort of backdoor, which the mayor has done in Hillingdon. I accept, query whether it's correct, but you bring this sort of backdoor of then saying, well, let's look at the criteria. But if we're going to do that exercise, then we still need to apply the criteria, and that must still be to say, are there alternatives which avoid this harm?
Mm.
And I think you have to do that to make a conclusion on D9 criteria, if and to the extent that we need to engage in that exercise. And that's obviously a matter which might be ruled on in a particular way by the court, but we need to do that. The question of optimization, I think it leads to a bit of a risk that rather than thinking about those things in those terms, you instead go to say, I'm going to build up, and up. I'm going to deliver more and more affordable housing. And the bigger I get, the greater the harm to heritage assets, but also the greater the weight to the public benefits. And I keep going and I cause harm and harm and harm and harm and harm. And I never stop to say, do I need to cause that harm in this location?
I thought that was the risk you associated with maximising rather than optimising. Optimising through a design-led approach in the London plan, does not lead to that, the infinite build, does it? It leads to a design-led approach to optimising capacity of sites like this one. Now, you say you agree with that, presumably.
No, I completely agree with that, but that's not what has happened here.
Exactly.
Because what's happened here is that instead you've said, but if I don't keep going up, I will deliver less affordable housing. And of course that's true, but that leads to a maximisation and not an optimisation.
I appreciate that. I think in the end we're agreeing, although I'm not, which is to say that I think the mission critical issue between us is not we'll see, we'll leave it for closings now, I think, but I'll be saying anyway, it's not so much about sort of alternative sites, which is to say, are there lots of better sites you could do this? Because if in the end, and it is a massive if, and I know you've set out your views, my team has set out its views, if there has been a design-led optimization of this site's capacity within the meaning of policies like D3, D4, then even if the needs, such as they were met off-site for 133 homes, there is an almost inexhaustible need to meet them here too, through a design-led optimization of the site's capacity, which you say hasn't happened. So that it does keep coming back, I think, to this point about optimizing. But I appreciate your point. You say one starts with D9 and we'll leave it for submissions, I suspect, in the end.
I mean, just to answer those points.
Please do, of course.
I think just to sort of draw it together, my take on this is that the D9 alternatives test is there to deal with the specific point that I've articulated, which is that the mayor hopes that you could deliver tall buildings without heritage harms. Now, it is possible that for many tall buildings, there would still nonetheless be heritage harms, but the mayor hopes that you can deliver them without heritage harms. Now, that is not true of this site, agreed not to be true, and we've harmed the setting of a heritage asset of the highest order with the proposals. Now, at that point, my reading of the policy, and there's good sense in this, is that you stop and you consider whether we need to do this at all. Do we need to cause this harm? And you do that before you carry out your heritage balance. And the difficulty that your client has pursued, the approach that's been pursued, is to say, keep going, keep going, keep going, harm, 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 but benefit, benefit, benefit. And that's said to be part of an optimization, because you're always outweighing the heritage harm by the claimed benefit. In my view, that's not what that policy is trying to do. And the real difficulty, the really profound difficulty here, is how we got here, which is that your client believed when this scheme was designed that it would cause no harm and it would cause heritage benefit. That was your client's position. It was the architect's view. It was the advice received from Taverners that that scheme would cause no harm and would deliver heritage benefits, including to the setting of St. Thomas. During the course of the history that we've been over, that conclusion became one that was unsustainable. But at that point, the scheme had been set. nobody thought to reconsider it. And at that point, your client turned around and said, well, okay, harm, but is it outweighed by these benefits, by 133 affordable units? And yes, it's outweighed. That was the view that was taken. But you've never gone through that process, because you fixed the design assuming heritage benefits would fall from it.
I think we've teed things up very nicely for the inspector for his for closing submissions next week. That was a little sort of starter for what to come. The other thing I just wanted to ask you was about conservation areas, and it was again something that you trailed in one of your questions to. Again, it's just to help me write my closing so I can understand, if you like, where you're at. You trailed in a question for Mr. Froman that there'd be a sort of a submissions made on the approach to conservation areas. In his proof of evidence, in Mr. Froman's proof, which actually, would you mind just grabbing if you can?
Yeah, sorry, just give me a second. It's
not take time.
Yeah.
I'll just let the inspector grab it. Good. In Mr. Froman's proof, if you flip through it to page 41.
Yeah.
There is a footnote.
Yeah.
That he referred us to in his cross-examination, I think it was. And he refers to a call-in inquiry, which that is a reference to the last year's Notting Hill Gate call-in decision by the Secretary of State. And it's one where Mr. Froman gave evidence to the inspector. The inspector was Christina Downs, just for our inspector's note, and the Secretary of State. In essence, that means the inspector noted at 399 of her report. There's a few lines down into the excerpt, and as you'll see, our inspector can see. What she says, what Inspector Downs says about this issue was endorsed by the Secretary of State in his decision. She said, it's important at this stage to address 2 points of principle. The first point is that the requirement to consider the effect on the significance of the asset as a whole and not just part of it. The use of views as a useful tool in the heritage analysis. However, it's not an end in itself. And in my opinion, the council made the mistake of being overly reliant on the effect of views rather than considering the effect on the significance of the asset overall. It's particularly relevant in relation to particular conservation areas here, i.e. up in Notting Hill. Because they're extensive and varied in character, this may mean that findings of harm will be more difficult to substantiate. Nevertheless, that's the approach which is required and it must be followed, ... Now, I wanted to check because it may be that there's nothing between us, and so in which case, no point bothering writing reams of closings about it. Are you asking our inspector to sort of do something else than that, or do you accept that just as a matter of principle that what's set out there is sound?
I don't think it's complete. And if I can just explain it in this way, that in the same way as I went through with Mr. Jones, the question of an impact on setting, I think you can, what you need to do is, in looking at less than substantial harm, is not just focus on what is preserved as a sort of deductive exercise of trying to identify what has gone, but actually looking at the impact in the round and looking at it sort of with an open mind, because there will be some cases where you can say that much of a heritage asset is preserved, and a large conservation area is probably a good example. But there could then be a really profound impact, So say if you were to demolish 100 houses in the central Fulham conservation area and replace them with a modern form of development that was entirely inconsistent with the character, you would preserve much of the conservation area because it's a very big conservation area. But you can't just dilute those impacts because of the scale of the asset. To my mind, the Tower of London is the best example. It's a huge heritage asset and it's got great presence. And therefore, on one view, it's very difficult to harm it. But the Secretary of State, for example, has recently accepted that a more than moderate degree of less than substantial harm was caused to it by a building a kilometre away, a single tall building a kilometre away, causing a more than moderate degree of less than substantial harm. And obviously that's a heritage asset whose setting is largely unaffected by the proposal. And its attributes, in fact, lie not just in its setting, but in its fabric and in the immediate appreciation of the asset. So I think that sort of analysis that you see here, which sort of connotes that the larger the asset, the more expansive the asset, it necessarily follows that there would be lesser harm if you were to interfere with any part of it. I think that's overly simplistic. I think you've got to, it's one of the factors, but I think you've got to look at it in the round. I'm not sure that really answers your question or helps you write your closing.
Yeah, it doesn't. It makes my closings much more difficult, I think. Do we agree that the sort of litmus test, if you like, when we're in this part of the NPPF, which is to say the heritage chapter and the relevant sections of the 1990 Listed Buildings Act, what we're after is the extent to which, if any, but here there will be some extent to which the significance of the heritage assets is harmed. That's what we're after.
Yes, that's right. You're looking at a qualitative judgment about the level of harm. You're not solely looking at a deductive exercise as to what is left.
I think you are actually. This is the problem, because if we agree that the mission sort of critical point is about significance, the extent to which significance is detracted from or not, here there is an agreement there will be some harm, TBD how much, but anyway. What matters, doesn't it, is the significance of the asset, the extent to which that significance is harmed. Now, if in the end something happens, whatever it is, whether it's a major intervention or a minor intervention, whatever it might be, it could be the tulip as your example, it might be 100 homes getting knocked down, it might be a single small building. If that causes very dramatic harm to the significance of the asset, okay. If it causes, whatever, less than significant, less than substantial, minor harm to the significance of the asset, right, that's what matters. Either way, the test is, what we're interested in is the significance of the asset.
If you're trying to, so yes, but, and the but, my training for witnesses is kicking in for me. Yes, but the but is this, that we do look at the significance of the asset, but when there's an asset such as a conservation area, which is a diffuse asset across a large area, I think you need to think about what actual harm is being done. And if I give this example, Mr. Simons, if you applied to put a front dormer on a house within the central Fulham conservation area, Hammersmith and Fulham Council would refuse it on the grounds of conservation area harm. Now, how does that register on the sort of significance Richter scale in terms of harm? How does it even register a single front dormer in a very large conservation area? The answer on your analysis, I think, would be it doesn't. And there is, or it is so minor that it would be outweighed by the slightest consideration. But it does register. It does register, and that's the difficulty with just saying here is my sort of collective significance, and how much do I subtract from it? You've got to think about what is the actual impact that I'm engaging with.
All right. Very grateful. I think that has helped actually for me to understand where you're coming from. There is, I think, a matter of principle between us on the approach to assessing the harm of in respect, I think in particular of conservation areas more than listed buildings is where it kicks in. But I'll leave it there. I think at least the inspector understands it, or understands what the lines are between us, and I'll come back to it in closing submissions. So, Mr. Turney, it's been a great pleasure. Thank you very much indeed.
Thank you.
Thank you, Mr. Simons. Thank you, Mr. Turney. Mr. Philpott, do you have anything for Mr. Turney?
So I do have a few points. I don't know whether you and indeed Mr. Turney, who's been on the stand for some time, would like to take them straight away and get them out of the way, or alternatively have a break. I don't mind, because I've just been listening, but I take your preference.
That has flown by this morning. Mr. Turney, would you like a break?
I'm fine to carry on, sir, if you want.
Let's carry on and have a break. Because we'll probably have to have a break anyway before we come to conditions. So carry on, Mr. Philpott.
Indeed, thank you, sir. Good morning, Mr. Turney.
Good morning.
Before we start, I should say I enjoyed your allusions to our case about the tulip, but I'm going to resist entering into any advocacy about that. I just want to deal with the status of what you're doing today. You're not appearing today as an independent expert witness.
No, absolutely not. Well, if I just say, I found it actually quite difficult, because I was have been asked by others to represent them, and I thought that inappropriate, that it wouldn't be an instruction that I would take on if I was acting as a barrister. I thought about calling myself expert witnesses at the inquiry, but to be frank, the cost of doing that, whilst not representing others, I considered to be prohibitive. I thought about just coming and asking to make a submissions statement, but I decided that really, if I was going to participate properly, that my case should be open to challenge in a way it wouldn't be if I just came and made some submissions. So, but that's a long way of answering. No, I'm not an independent expert. I'm not an expert on this subject matter. I'm just familiar with it.
I think to be fair to yourself, Mr. Turney, you do have expertise in law and the interpretation of policy, and I don't think any of us would want you to step away from that claim. But you rightly accept, I think, that you can't claim to give independent evidence on those matters because, as you've acknowledged, you have an interest in it.
That's quite right, and I think I acknowledge, and the inspector, and you'll doubtless say, and the inspector will probably find that as a result, it is not wholly objective, because when one's talking about an impact on one's home and family and neighbours and friends, it's very difficult to be objective, and it's for that reason that I would have declined the brief, which I was in essence offered by my neighbours. I would have said no to it.
So the matters that are within your expertise are for submission rather than evidence in this case.
Yeah,
we can.
I mean, what I should clarify is that in terms of points of law that I've made already and that I may make in submissions, I consider that I'm under the same duty as I would be under if I was acting for a party. In other words, I must put those points fairly, not in a way that misleads on the law, not in a way which is unarguable, and treating those matters as owing a primary duty to the tribunal. And I hope that whatever I say in submissions, that both you and Mr. Simons will appreciate that whilst they might be within a range of views, that they're being put consistently with that professional obligation. But in terms of commenting on townscape or heritage impacts, it's my inexpert and to an extent, subjective view.
Yes, Mr. Tony, I don't think you I think you're potentially tilting at something which is not actually the point of my question. My point is simply this. There are areas where you have expertise. You rightly claim that in respect to those areas, you're not independent, so you're not giving independent expert evidence, and therefore those are matters for submission. Now, I work on the assumption that all of the things you say about making sure that you don't mislead, misrepresent, I take all that as read where you're concerned, Mr. Attorney. I assume that will be correct. I'm just clarifying the scope of what you're giving evidence about in order to, through that, to explain to you and to the inspector the scope of my questions. So that's all I'm doing there. Now, you have provided written evidence from 2 experts on the main issues, which are matters, we can agree, requiring expert appraisal and judgment.
Yeah.
But you have decided, not a criticism, but you have decided not to call them to give oral evidence and to answer questions.
Yes, that's right. I think, I've just said why that was. I considered putting together a team for the inquiry, but as you'll be aware, the costs of that become very substantial and frankly would not be in my family's interest as a whole to spend that much money on.
As I say, Mr. Taylor, there's no criticism at all, just as a matter of fact, but you'd also recognise that the fact that they haven't been made available for questioning must necessarily affect the weight that can be attached to their views, just as a normal matter of course.
Absolutely, and I weighed that in deciding to approach it the way I did, and I know you made that submission, so.
Yeah, I didn't think it would be controversial. So in that context, the questions that I'm going to ask you are genuinely matters of clarification so that I can understand the scope of your case, and in particular those things which you deal with as opposed to the things that your experts have dealt with. And just one, before I go into those matters, as a point of fact, I just want to check. In your oral evidence, you've made reference to the Hillingdon litigation in relation to policy D9. And you drew a distinction between the facts there and the facts here, because you said, well, in this case, the local plan has identified areas suitable for tall buildings. And I took it from that, and that's what I want to check, that you had understood that in the Hillingdon case, they had not in their local plan gone through the same exercise and done the same thing.
I think you're right to pull me up on that. I think I was actually in making that point, I was actually eliding 2 different examples. We mentioned earlier the Ealing example, and my understanding there was that there was an absence of identification. In Hillingdon, I don't know. I don't know.
If I can help you, what I'll do, just to save time, and you can look at it if you like, the skeleton argument put in on behalf of Hillingdon, which is in the core documents at CP 14.9, there is a summary of the factual background, and at paragraph 6A, it identifies that grounds of non-compliance with relevant policies for tall buildings, and then it includes DMHB 10, Hillingdon Local Plan Part 2 Development Management Policies, which identifies Hayes and Uxbridge town centres, but no other areas in the borough as appropriate for tall buildings.
Sorry, can you just give me the paragraph reference? I struggle with the document.
It's paragraph 6A. So I'm just trying to see if, yes, it's page 3, I think, of the PDF.
Yeah. Okay.
It just on, I mean, on the face of it, it would appear that in that case, like here, the local plan had identified areas as appropriate for tall buildings, but no other areas. So that it was a similar position where there were areas identified in the local plan as appropriate for tall buildings.
Yes, yeah. I'm happy to work on that.
Thank you.
Resumption.
If that turns out to be wrong, please let me know outside the inquiry. I don't want to
no
on a false premise, but that would appear to be the facts there.
Yeah, I suppose the point that I wanted to emphasise is, and it may be that there isn't a distinction to be drawn, but in my view, the fact that this borough has done what everyone seems to agree would be a London plan compliant job of assessing the locations of tall buildings and making decisions accordingly, and it has in fact designated large areas of the borough for tall buildings, it is a matter that goes to understanding how to deal with the conflict with the locational principle in D9 when looking at the development plan as a whole and whether you're compliant with the development plan as a whole. I hope that makes some sense, but I don't know. But making that point, I'm not sure if I should draw a distinction with Hillingdon, and if I did, I think perhaps from what you've said, I shouldn't have done so.
Grateful. I understand. I'm not going into the detail of policy. We can make submissions about that, but just as a question of fact, we'll see what the court says about the issue of law. But there would appear to be that commonality between the two plans.
Yes.
Correct. So the next questions that I want to ask you about, they arise from your combination of your statement of case, if you could take that up, and paragraph 20. So you need to have that open, and you also need to have your proof of evidence open in section 5, which starts on page 12, and seems to be where you deal with these aspects of your statement of case in the proof. And there are just, I just want to check where we are on a few of the points that you've raised for the Secretary of State's consideration. So let me know when you've got those two documents open.
Yes, I've got those, thank you.
I'm grateful. I don't need to go through all of them. There are just some points I want to clarify. In relation to your paragraph 20 C, this is the place-based point, and you dealt with this in your evidence in chief. You said it would fail to make any appropriate provision for place space and open space, and then you say the contribution proposed is wholly inadequate. If I look at what you say about this in your proof of evidence, you identify as a matter of fact in 5.4 that there is no play space to be provided within the site. Can I just understand, is it your case that an effective and efficient redevelopment of this site for affordable housing should include sufficient play space on site to reflect the GLA's calculator? Is that your case?
But if you mean this site, the red line, then I think it probably wouldn't be able to. But the thing is, Mr. Philpott, the red line is a bit of an artificial red line in circumstances where at least the circulation areas, the common areas of the estate are owned by the same person, or at least by the person who owns 50% of the development. So the answer is, I suspect if you were to develop this red line site for housing, you would have to look outside that red line. But a blue line, or indeed a bigger red line, could have included large areas of the estate. And for example, there are parking areas, there are bin stores, the inspector will see and take a view on the efficiency and appropriateness of the rest of the use of the estate. But why not simply expand the application site and come up with a concrete proposal? or indeed why not in the way that the council did with the parking spaces. And you recall that there's no ability to accommodate the blue badge parking, or at least not visitor blue badge, I think it was, within the red line. So it put in a separate application to apply for planning permission to accommodate that need. It did that and obtained that planning permission, and that's how the blue badge parking bays, as I understand it, are to be consented. Well, exactly the same approach could have been taken for any other part of the site, any part of the estate which the council controls. It could have come up with a public realm scheme and applied for planning permission for it, and it could have been secured. So that's really the point. But if you're just on the red line, I think it would be difficult to accommodate under 5 type play space. It would be possible, I suppose, to provide some kind of play, integrate some sort of play into the landscaping type area. But I'm willing to assume that if you were to develop this site, you would look towards a similar footprint within the red line.
And if I think it follows from what you're saying, that if one were to try and achieve a level of play space to reflect the GLA's calculator for a development on this site, that it would have to involve the change of use and redevelopment of other areas within the estate. That seems to be what you're suggesting. Have I understood that correctly?
If you were to look off-site, which I think you probably would need to meet the quantitative needs, I think almost the problem is, Mr. Philpott, that the quantitative need is a factor of the scale of the building. So the quantitative need, a building of 10 stories would have half the quantitative need, and then the question starts to become a bit different. So it's quite difficult to say. A building of this scale creates a quantitative need, 780 square meters of play space. You would, if you're going to provide that, you would need to look for off-site provision. That's obvious. I mean, the site, that's bigger than the site, I think. The need for play space is bigger than the site. So it's quite obvious. Even if you were to, I suppose the only thing to do, have some sort of rooftop play space and pedestals, I don't know, but there are, you know, it's bigger than this, the requirement's bigger than the site. So you would need to look, you'd need to look at the wider estate as the most likely place to put it.
Yes, but I mean, in a sense, the answer you've given, I think, crystallizes the point that even if you were to develop at a significantly smaller scale, but still seek to provide a level of affordable, level of housing on here that optimizes the site, you would need to look at some significant changes of use and redevelopment of other areas of the estate to create new play space to meet the calculator. We don't have a particular alternative from you to look at, but you can see just from the figures that you've given that you'd be looking at hundreds of square meters for any sort of development that optimizes this site. Just because of the way the calculator works.
Well, I'm not sure that's right, because you have there's two elements to the calculator. So you've got yield, and then you've got a simple multiplication, 10 square meters. But then you have to look at sort of what comprises the yield. So in terms of who is being catered for, and the assumption is that a 16-year-old will probably try and get as far away as possible from their house to go and play, and therefore you can look to a greater range of locations. So if you're dealing with a different proposition, you have to start again, work out the yield and work out how that yield is comprised. And if to put it very simply, if you had exactly the same mix and half the number of units, your yield of 5-year-olds on the calculator, 5 and under, would require 200 square meters of play space. Play area A is 200 meters of play space. So
So are you saying in those circumstances you wouldn't need to provide any new play space because there's already one there?
No, then what you should do, and what your client should have done and failed to do, is look at how that's used and look at whether it can accommodate the yield of the development. And if it turns out that, you know, there's a queue for the swings on a sunny afternoon, then the answer would be no, we need to provide something more. We can't just assume it will be absorbed into what's already there. But you may be able to deal with that, because you may be able to say, well, let's improve it. Let's put some more swings on it. Let's put a roundabout on it. That's the way in which you deal with this. It's the way in which a developer would normally deal with this. The difficulty here is that what's happened is we've sort of just said it's £50,000, and it took until a week before the inquiry for anyone to answer my question about what does that mean? What's it for?
Mr. Turney, you're, if I may say so, you're deviating away from my point. I think I've got an answer to my point, but the difficulty is we don't have a specific alternative from you that suggests what you regard as optimal development of the site. Not a criticism, but as a matter of fact, I don't have anything that I can test with you to see what that would produce, do I?
Well, I can put it in these terms.
Or just as a matter of fact, I don't have a specific alternative from you that you say is the optimal development of the site that I can test.
No, I have not drawn. Sorry, are we talking about the play space?
I'm looking at the
play space.
The redevelopment of the site.
The optimal.
The optimal. I don't have something from you which I can test as your alternative analysis of the optimal development of the site, do I?
Is this, sorry, have we moved away from play space?
No, because it comes back to the question of how much you'd have to do off-site to meet the result of the GLA calculator. What I don't have is an alternative from you to which I can apply that calculator to understand the implications off-site. As a matter of fact, I don't have that.
I agree as a matter of fact, but I'd add this, that if you had half the number of units, then a 200-metre play area within 100 metres of the building would, in isolation, be sufficient to meet the needs of under fives. If you had half the number of units, you would still have to ask yourself whether it has the capacity to accommodate those additional users. But subject to that, and I don't know the answer to that because no one's ever done the assessment, I certainly haven't. Subject to that, if you halve the number of units, play area A would be of a size that could in principle accommodate.
Thank you. Now, the concern you've raised in oral evidence about ring fencing of funding, if that was the issue, that's something that could be addressed in suitable terms in the 106, if that was an issue which was a deal breaker, couldn't it? You could ring fence the funding by reference to play space, and you could ring fence it by reference to distance if that was thought necessary.
Well, yes, but what you need to do to understand that then is start to articulate what exactly it is would be done with the money, and the sort of vagueness of the terms of the 106 is reflected in the vagueness of how it will actually be spent, because we simply don't know. I think if you say it has to be used for play space within 100 metres of the building, then we'd probably want to at least articulate what that means, rather than just saying, well, we spent 50,000 on some other play areas and this is what it looked like. I think we'd probably want to understand what that actually means.
And as I understand your position, you think that it would be better to ring fence it rather than to allow the residents of the estate in a stakeholder-led organisation to decide how best to spend it.
I absolutely think that, and that's not to diminish the importance of their decision making for how the estate is operated, but this is about the imposition on the estate of 133 new dwellings and the accommodation of the impacts of those new dwellings. And I suspect that residents in the estate will have existing priorities where they would wish to spend the money. which may be significantly different from what the needs of the new residents will be.
Well, I understand your position on that. I can make submissions on that. The next matter I want your help with, if we go back to your statement of case, and it's paragraph 20E, and it's to do with fire safety. And you say in your statement of case that at the end of E, it's unclear that such proposals remain acceptable in terms of safety, and it's unclear whether the design of the building has been properly assessed in terms of fire hazard. Now, when I look at your proof of evidence at paragraph 5.9, you simply repeat what's said in your statement of case without elaboration. As a matter of fact, that's what you do.
That's right. There are parts of my proof which are simply cut and paste from my statement of case because I didn't feel the need to add anything to them.
What you haven't done in your written evidence or in your oral evidence today is make reference to the specific fire safety assessments that were undertaken or seek to analyse what they say. Have you?
No. And can I just explain why I don't contest those expert assessments, but there is, as you know, there's a ongoing inquiry into the way in which building safety is dealt with generally, and the assessments that have been carried out are under the extant basis for assessing fire safety. The Secretary of State will have uppermost in his mind a question as to whether single core, very tall buildings remain the correct approach to delivering large-scale social housing. He will have that uppermost in his mind. It's a matter which is being examined in detail through the inquiry and the tragic circumstances, a few miles up the road from this site. And I think the inspector probably just has to report it as that. There's been representations from others. I can't resolve what the Grenfell inquiry will decide.
Mr. Turney, I think that you would need to acknowledge that what the inspector needs to do is report on this issue by reference to policy D12, for example, of the new London plan, which has set out in a very recently adopted development plan what must be addressed in terms of fire safety. And he has the benefit in CD 1.16a of an assessment by an expert against those policy requirements. And for the purpose of development control, that is an exercise the inspector in due course Secretary of State will need to take into account.
Absolutely, and I think inevitably he will, so you will report that on the evidence you've seen there is compliance with the existing policy framework. There remains in my mind a significant question, which I think will be in the Secretary of State's mind, as to whether this general approach to accommodating social housing remains the right one.
Very well. I understand your position, Mr. Sen. You very fairly set out what you say the position is on the policy, so I can leave that there and leave that for submission. The next point in your statement of case is F. You say there is no provision for contributions to local services. Now, if I go to your proof and look at what you say about that at the bottom of page 13, it's paragraph 510, you say there's no provision for contributions to local services such as schools or healthcare. I find this surprising given the scale of the development. So that's the extent, as I understand it, of your elaboration on the point in your statement of case.
Yeah.
And I don't believe that you've identified any other specific infrastructure in your proof of evidence as opposed to schools or healthcare as being a concern here.
No, that's right. I mean, To be frank, I don't think it's the biggest issue at this inquiry. I could have pursued the point with more rigour, but in light of the time that was available to me, I haven't pursued it. And I think I probably, in fairness, because I haven't taken it any further, I should probably not pursue it, because I'm still surprised, but surprise is rarely seen as a planning policy test.
No, you see, Mr. Attorney, in response to your statement of case, we have, of course, produced evidence through Mr. Wilson that there was an education and primary healthcare assessment, CD 1.7, and it's not just a matter of saying, well, I haven't had time. I mean, you haven't adduced any commentary or criticism of those, or any reason to suggest they're wrong.
No, that's it. I mean, an explanation has been offered. What I mean is I haven't had time to apply any substantive technical scrutiny to that justification. And in those circumstances, I think in fairness, and I said this already, in fairness, the inspector should record that the point was not pursued.
I'm grateful. And then finally, in your statement of case, paragraph 20G, you say it's unclear that the proposals will have an acceptable impact on the local sewer network, which is prone to flooding. Now, I don't think there's anything in your written proof about this, but is that because in the statement of common ground, which we entered into with you before the inquiry, it records agreement with what was said in the statement of common ground between the local planning authority and the applicant about these matters?
That's right, and to my mind, that had resolved that issue as between us. So apologies for not making that clear orally earlier, but to my mind, the statement of common ground had resolved that point.
Thank you. I say it's not a criticism. I simply wanted to make sure that I had understood that correctly. And then the only other point that I wanted to just check with you, it's in relation to Ms. Brown's evidence that you've appended. And again, this is just to clarify how it sits with your own case, because you made clear in your oral evidence that this is evidence upon which you rely. And if you turn to her response to the officer's report, response to the planning committee report, and when you've got that, go through please to paragraph 14. This was Ms. Brown's commentary on the application of former London Plan Policy 77. You see that?
Yeah.
And looking at criterion C, relationship with the surrounding buildings in the public realm, she says this: agree that the development site varies significantly between the modern high density scale and design of the buildings within the Clematley estate and the development south of the site, which is typified by Victorian terraces. In our view, this site would therefore lend itself to a building of a scale that is transitional between these two areas, i.e. between 2 stories of the Victorian terraces in the south and the 3 to 7 stories which forms the southern part of the Clematley estate. And I just want to understand, that seems to be an expression of view by your townscape expert as to what would be the appropriate scale of development on this site. Have I understood that correctly?
Yes, that's how I read it, yeah.
And there's no further detail, I think, to look at, but what we can glean from that, I think, is that she is suggesting the appropriate scale is somewhere below 7 stories, somewhere between 2 and, well, she says in 3 to 7, unless it means 2.5, it's somewhere certainly below 7.
I think that's a fair reading. What I'd add is obviously transition is part of the policy requirement, and clearly you can't be overly mechanistic about transition, because height alone is not likely to be solely determinant of transition. But what's absolutely clear, in my view, and I think actually not disputed by the townscape evidence that the inquiry has heard orally, is that the building of this scale does not provide a transition from the south. It doesn't provide a transition.
Mr. Timothy, feel free to make whatever submissions you want, but just to understand, your understanding of your experts' evidence upon which you rely is that the building would lend itself to a scale below 7, somewhere between 2 and 7 stories. I've understood that correctly. The
site would lend itself to a building that is between the 2-story terraces and the 7-story buildings that you start to get to in the site.
So fewer than 7 stories, but somewhere between what, presumably 6 and 2.
Yeah, that would provide a transition.
Yeah, and that's the only evidence you've adduced as to what scale of building would be suitable, having regard to the relationship with surrounding buildings and public realm.
Yeah, I mean,
if I've missed something, take me to it. But as I understand, as a matter of fact, that's the only evidence you have adduced as to what would be an appropriate scale of development of this site, having regard to the relationship with surrounding buildings and public realm.
I think that's right in terms of a number of stories, but can I just clarify that, which is that transition is one of the factors. It clearly is one of the factors. And her evidence there, as I read it, is that thinking about a transition and talking about townscape terms, the site lends itself to that sort of scale of development. And that's her professional judgment, Ms. Brown's professional judgment. And as I'm the person giving evidence, I'd say that in my unprofessional judgment, or non-professional is probably the best way to put it, I agree with that. Now, there are, of course, other considerations, and it may be that a building of greater height could be delivered on that site, but I think probably not. And the reason I say probably not is because once you start to get to that kind of height, you would, or beyond that height, you would lose any sense of transition. It would be an abrupt change. Also, as we've seen from the exercise that sort of we did in cross-examination, to reduce a building on the same footprint such that it didn't cause harm to the setting of the Grade 2 star listed building, you would probably be looking to that sort of height, a 7-story building or less. And I think probably finally, even if you were not constrained by the setting of heritage assets, and of course, 7-story building, I think would pretty much avoid impacts on the conservation areas. But even if you weren't constrained by the heritage assets, I think that you still have to come back to the tall building policy. And the answer from the tall building policy, I think, is this: that in principle, this site is inappropriate for a building of more than about 7 stories.
It's a very long answer to a short question, but it inevitably prompts a couple more just for clarification. Your understanding, and tell me if I've got this wrong, is that when your expert witness expresses the view, it's our view, so this is would seem to be a collective view of her group, but in any event, that the site would lend itself to a building of a scale of between 2 stories and 3 to 7 stories, that she's not there taking account of anything else other than the issue of transition, that she's shutting her mind off to all other considerations that might influence the scale of the building, just looking at transition. Is that what you've understood?
No, not just transition, but townscape and character and appearance, and not heritage, and not optimization or benefits.
I see.
But in townscape terms, that's Ms. Brown is clear that she deals with the townscape impacts, and it's divided from Mr. Griffith's evidence, which deals with the heritage implications. What she's dealing there is the townscape implication.
I see. So your evidence is your understanding of your witness's evidence. I can't ask her about this, but you've obviously commissioned her to do this. Is that what she's done there is to identify an appropriate scale without any regard to, say, optimization or CH8 in the London pattern or anything like that. She's taken no account of those. That's your understanding.
Well,
she's either one or the other. She's either just looking at townscape and shutting out those other considerations, or she's taken all of those things in the round and formed a view. Which is it?
I don't think it is that binary, I'm afraid, because the optimization requires you to understand the capacity of the site to accommodate development, to accommodate built form. And if in townscape terms, you reach a conclusion that the site cannot properly accommodate more than about 7 stories of built form in townscape terms, then what you are concluding is that the optimization of the site will be in that range. That's what you're concluding. That is the townscape parameter to optimization. Now, there may be other parameters to optimization, but that creates the envelope in which you optimize. You say in townscape terms, what can this site accommodate? In heritage terms, what can this site accommodate? In place-based terms, what can this site accommodate? You look at all those constraints and then you come to a conclusion. And on the townscape element, it's a ceiling she feels in townscape terms around below the 7-story height.
So I think I understand the way you characterize it is that the townscape element, and she's looked at that in isolation, creates a limit. So other factors would force you either below that limit or allow you to build up to it, but not beyond. Is that the way you've understood the exercise that she's carried out?
That's how I understand it. Put another way, if she was acting for the developer and the developer had come to her and said, how many stories should I look to on this site in townscape terms? Her advice would have been below 7.
Yeah, and so far as I understand your position, not expressed as an expert, but taking it as it is, your position is that when you build in all those factors in your own mind, the optimization, policy H8, matters of that sort, you come up at a limit of somewhere around 6 or 7 stories. That's your own inexpert, but that's your view.
I think in townscape terms, I think that is my view, and I think so. You'll form your own view on that. But in townscape terms, I think that's how the site strikes.
And when you've and when your witness has looked at this, have you given any consideration to the number of units that would provide?
Sorry, the witness. No, Ms. Brown, no, not that I can see that she's analysed the yield that you would obtain from the site with a development of that scale. In terms of my own understanding, I think it's a mathematical formula on this plan form, 7 per floor, 7 per story. On a different plan form, I do not know. I do not know how many units you could deliver at 6 or 7 stories. But what I would say, Mr. Philpott, is that's the kind of job that in cases like this, which I'm normally involved in, the architect has at least turned their mind to. And the striking feature of this case is the complete absence of any attempt to assess the capacity of the site. And I can see why it's happened. It's happened because of the previous baseline. But once that's gone, nobody bothered to think about the capacity of this site in townscape terms. They stuck with plan A, and that's the mistake.
Well, Mr. Tenney, I've got your evidence about what you think the optimum scale of the site is, and we can consider that and we can make submissions about it. What I don't think as a matter of fact, that I find in your evidence or in the evidence of your witnesses is any assessment of whether such a scheme would be likely to come forward. A 7-story or 6-story scheme. As a matter of fact,
no, that's right. As a matter of fact, but no, you're right. As a matter of fact, I do not assess whether that scheme is likely to come forward. However, I've been keen to explore with your witness and indeed with Mr. Henderson as to whether there was any viability reason for this scale of development. Development economics for purely social housing or purely affordable housing schemes work fundamentally different from market appraisals, in the sense that you have to look for external funding in any event, and therefore you're not just assuming that if you build more, that it will be better in viability terms. The economics of social housing schemes can be turned on their heads, because it may be that for each unit built, you are spending more money than you get back. So the viability can be turned on its head. There is no viability reason for this scale of development at this site. And I don't hear it said, at least since the officer's report in 2017, that there has ever been a viability justification for building at this scale.
Just Tony, just as a matter of fact, you're not adducing any evidence or analysis as to the likelihood of a development of this site at under 7 stories, are you?
If you're asking me the question.
Yeah. Yes or no?
The answer is, have I dealt with? If the question is, have I said in my proof the likelihood of developments at any particular scale? No, I haven't.
No.
If the question, but I'll give this answer if I may, that I think that this site will come forward for housing and should come forward for housing, and the council will bring it forward for housing with the funding pot that they've already established at an appropriate scale if this proposal is refused. That is my view, my strong view. This site will not be left derelict. It will come forward. It is owned by the council. There is funding in place from Watermeadow Court to deliver affordable housing here or elsewhere in the borough. There will be other sources of funding which are already in place. And therefore, I think it is highly likely that the site will come forward at an appropriate scale if this scheme is refused.
Mr. Turney, I think I can deal with the rest of that in submission. Thank you very much for your time. Those are the only questions I have. Thank you.
Thank you.
Thank you, Mr. Philpott. Thank you, Mr. Turney. I'm going to suggest we have a break now, and then we'll come back and talk about conditions and the obligation. I have had the opportunity to have a brief look yesterday evening at them, so I don't propose to be very long. There wasn't a great deal I needed to ask, but we'll need to go through the process. So, well, what do you suggest? We can break for a quarter of an hour and come back and do that, and then have lunch, or would you prefer a longer break?
If it's possible, because I don't have Mr. Wilson, and I've only managed to get part of the way through the conditions. If we have an earlier lunch break, so
let's do that then.
Those as I eat my sandwich. And then we can deal with it all in hopefully one fell swoop. Okay,
I'm content. Mr. Turney, you happy with that?
So could I just ask that? I'm happy with that. Could I just ask that somebody sends me the list that we're going to be using,
please,
if it is different from what I've seen before?
Okay.
We'll make sure that's done. It's not materially different, but you need to have the up-to-date version.
Okay. Should we say 1:15 then? Is that okay?
That would be fine. Thank you very much, sir.
1:15. Good. I'll come back then. Thanks for this morning. That's been most helpful. Good afternoon, everyone. I think we're at 15:15, so great. Thank you. I should ask. There were a few names popped up on my screen this morning that I didn't recognise. That may be me, but I'll ask now whether there are any third parties on the call who wanted to address the inquiry. Nothing's been brought to my attention to that effect, but if there are, if you could let me know, I'm happy to hear from you. It appears not, but I'll ask again before we get on with things on Tuesday, and hope that doesn't mean that we've got a flood of representation before we hear closings. But well, it would be remiss of me not to. But I've asked again today, so we are where we are. Conditions and the obligation. So you'll be familiar with the process. In a Secretary of State report, I'm going to have to report on conditions and the obligation, whatever my recommendation. So it's as well to go through them with some care, because they'll have to be represented at the back of my report in due course. So I'm going to go through them. What I've got on my screen is core document 220. Now, I don't know if there was something updated from there circulated this morning, but if there was, it's not arrived in my inbox. I should say I have got the council's reports on 5-year housing land supply. They've arrived with me. I haven't had a look at them, but they've arrived with me. And I've also got the replacement AVR 10. So that's arrived with me. So I'll attach those as inquiry documents. But I think for the purpose of our conversation on conditions, certainly we can go through these, most of them in fairly short order, but I did have a couple of queries, and I'm happy for anyone who wants to chip in. So feel free. The first couple of conditions on there: time limit, commence within 3 years from the date of the decision. That's no surprise. I don't suppose we need to dwell too long on that. The second one is setting out the approved plans. The list, what I've got in front of me doesn't have the numbers, but I think the numbers are in the statement of common ground, so they can be brought in. That's fine. So no surprises with those. The community liaison group. I was interested in that one. I'm not questioning whether or not it's necessary or anything like that. I just wanted to be very clear what it's doing. So it's to provide, as I'm reading it, to provide some way of liaison between the developers or the contractors who are putting the building up and those who live on the estate and around and about. So there's some forum set up where any issues that are resulting from the construction process, which, let's face it, would be quite an enterprise, can be aired and dealt with. I've not seen it put quite like that before, and there is a construction management condition further on, but I was quite happy with that, as long as I'm understanding it correctly.
So that's my understanding of it. As I made clear at the start, one of the difficulties I've got is that I don't have someone to take instructions from, but having read it, that was my understanding of the purpose of the condition.
Yeah, I'm content. I have no issue with it. 4 and 5. Yeah, I mean, one is always concerned, and you've probably heard other inspectors say it and me say it before. When one's dealing with a proposal that is presented to you as an exemplary piece of architecture, one is always concerned about how the concept or the idea of what is put in front of you is translated into built form. So I'm always interested in these conditions. I mean, certainly for where samples of materials have to be provided, there is some materials some material about the materials in the architect's proof, which was quite interesting, about precast and how it was profiled and how it was finished and so on. So I think, yes, it's good that the council have some jurisdiction over that. And 5 requires a number of important elements of the architectural form to be submitted in more detail to the council for them to approve. All I would ask is, I would ask the council whether you think that is sufficient to ensure that what's drawn and what's shown in the visuals and what's been explained by the architect translates into built form, because one is always very concerned that, planning permission is granted. I'm not saying it would happen here, but it does happen. But then there's a process of value engineering, or however you term it, and things get a little watered down, and it's not quite the build. What goes up isn't quite the building that was proposed in the original application. And I just need to ask the question is whether there's enough there.
Well, so what I would say is that I also discern that is the purpose of the condition. It is intended to ensure that the building is built out in a way that reflects the concept that has been presented to you. It's not immediately obvious what better alternative way there is to achieve that.
Well, that was the question, yes.
Whereby a particular architect must be retained. I have my doubts about whether or not that is A, adequate, or B, a proper condition and properly justified. Whereas I think the concept behind this, that more detail of the key elements must be approved to make sure that it's not built out in a way that is inconsistent with the concept that has been approved, would seem as a matter of principle to be a sensible approach. So I'd need to take, I assume, because this is agreed, we're content that is sufficient. And in the absence of a suggestion as to an alternative way of achieving it, I'm not in a position to suggest that more is required.
Yes, I think I've seen it included in 106 agreements that a named architect is retained, but I'm not sure whether that does the job either, because just because the named architect is retained doesn't mean that things can't get diluted. Mr. Henderson?
Yeah, no, I agree. I think it would be difficult to we've come across this position before where there's been pressure to tie the architects. As much as anything else, it ties the hand on being able to negotiate a good contract for the next stage of the development process. Bearing in mind it's a publicly led project and funded project. So not that I'm saying Henley Ale Brown would do that at all, but it is a consideration. I don't think it's a scheme. Yes, it is a very high quality scheme, but I don't think it's a scheme that only Henley Hale Brown could take forward to the build stage. And I think it is something that needs to be considered in terms of the design detail rather than the particular architect.
I think what I think that's right, and I think I draw some comfort too from the amount of detail that's been put forward in evidence to this inquiry and in the design and access statement, that the composition of the sort of panels of which the building is made up has been set out in some detail, in 3D details of how it would be profiled and finished and so on. So clearly the council has some reference point for what comes in, it would come in pursuance of this condition. So I do draw some comfort from that. So it's not like I've got a sheaf of 1 to 100 or 1 to 50 scale drawings where that kind of process hasn't really happened. So yeah, I'm content. I'm not going to I can't suggest another way of doing it. It's something that scratch your head about. But I'm not sure there's an easy way of doing that, other than the council having something in the condition that it can, if something comes in that it's not happy with, it can say that it's not happy. And this is
exactly, sir. And I did contemplate whether reference to the design and access statement would be officially added. That is a possibility. But of course, if the council concluded that something wasn't acceptable and it was able to point to the fact that it was inconsistent with the design and access statement, that would be a good arguable ground for refusing something in any event. So that I'm not sure it adds a great deal if you put the DAS in there.
Mr. Turney?
So I don't have anything about the overall approach to approval of detail. It was more, it seemed to me that condition 4 and perhaps some of the others is sort of not quite worded for this development. So details of the colour, composition and texture of the metal and stonework, but the overwhelming material is concrete. Would not be better to at least refer to and concrete. That. And there's references to balustrades, to roof terraces and so on. And, you know, obviously that's not something which is provided in this development. I don't have a problem in principle, but it just seems to me that the real nuts and bolts of this development, the points where the local planning authority is going to want to really be certain that they're approving the right thing, is probably going to be the concrete.
I think that's quite right. Yeah.
So I don't think there's any difficulty with picking up those points, but obviously where there are things which don't feature, they shouldn't be included in the list. And if there's any doubt as to whether the concrete should be part of that, I'm not aware that that is a deliberate omission, and it seems to me that it is a matter of completeness and for the avoidance of doubt, that could be addressed in the wording.
Okay. Well, can I leave that with you to have a look at? I think that it does crop up in a few other places, some of which on the conditions in front of me have been picked up in red, reference to shop fronts, for example, and so on. Let's move on. 6, rooftop plant details. Yeah, so any changes to the rooftop plant have to be submitted and approved by the local planning authority. I wasn't entirely clear whether that was pre-construction changes or whether it was, you know, once the thing's up and running, whether it needs to change beyond that.
I think we were suggesting that it shouldn't be a pre-commencement because it means that any change that happens at the top would, you know, when it's inevitable that, you know, there may be really fine-tuned design changes that happen at the top during the construction process. So I think we just felt pragmatically it was better to avoid that as a pre-con.
Okay, as long as I'm understanding that correctly, that's fine. Number 7 and 8, that's a construction management plan. So that requires the submission of, well, a CMP to be submitted to and approved by prior to commencement of development. And then it shows a whole list of things that would need to be done: phasing, basement and ground floor structures, piling, method statements, all the usual things. And then working hours, 0800 to 1800 Monday to Fridays, 0800 to 1300 on Saturdays, as you'd probably expect. And then it deals with the ultra low emission zone vehicles. Yep. Then the logistics plan is more about method statement for how it's actually going to be built. I can see why the council needs some oversight there because of obviously the proximity of people who are going to be living next to a major construction site for a while. So I've got no real difficulty with those. Nothing to add really, unless anyone else does.
Yes.
Good. 9, cycle parking. So that's preoccupation, which would make sense. Yeah, and retain thereafter. Yeah, happy with that. Cycle parking management plan. So is that there to manage how people park their bikes, so that there is some, I don't know, somebody overseeing keeping it neat and tidy, or where people park their bike, or how parking spaces are allocated to different flats or something?
I suspect so. So I think because of the scale of the provision,
Yeah.
It is going to require some management, and so that would seem to be the obvious explanation for that condition, and one can see why that might make quite a difference to the usability and longevity of the cycling provision.
Yep, I can see that. 11 is, well, 11 and 12, refuse. So yeah, provide the refuse storage enclosures before occupation, obviously, yeah, and recycling. And where it's stored, that's fine. That needs to be managed. Then a waste management strategy. So that's waste management when the building is in use. So that's how that, yeah, I can see 133 units need some care.
I've just noted an error and it's only a numerical error in the cycle parking on condition 9. I think it should say 224 long stay and 8 short stay. So that's my understanding of the changes, but as long as that's accepted, that can be clarified.
Okay, well, I can leave that with you, because what I'll probably see at the end is in the period between now and next Tuesday, if you can all have a look, if you get half a chance, and pick up any questions and so on, then that would be helpful.
Can I point out a really small typo in 12 as well? In the second line, I think it should be has been submitted to and approved in writing by the local planning authority, just to make it clear it's not the local planning authority that submits it to itself.
Yes, it's been submitted and approved in writing by the local. Yeah, conditions binding the LPA. Yes, thank you. That's helpful. That's line 2. 13, delivery and servicing management plan. So yeah, 133 flats. If where I live is anything to go by, there'll be delivery vans, supermarkets, goodness knows what. Yeah, so that does need to be carefully handled. So it is right that somebody has some control over that. Hoardings. Yeah, so that's to secure the site while works are underway. Yeah, of course. Now 15, 16, 17, 18, 19, 20 are all about the potential for contamination. Yeah, in a city urban site. We don't know what's gone on there, other than it was well, it would have been cleared post-war, wouldn't it? So goodness knows what happened in the dim and distant past. So there at least has to be the potential for contamination, which is I think the test these is, unless you can definitively rule it out, you end up with a string of contamination conditions. I've got no real issue with that. That seems to be necessary. So unless anyone demurs, I'll move on. Secure by design. We heard some discussion of this in the architect's evidence about the way that the foyer in particular had been designed. Yeah, CCTV and so on. Access controls, basement security. Okay, that kind of condition is not abnormal. Now 22, 23, is about landscaping. There is a landscaping scheme, some hard landscaping, some soft landscaping. It's right that obviously that the details are approved by the council, and there needs to be some provision for management. I think there's a condition later on about what happens if any part of the landscaping scheme gets diseased or damaged or dies. So we'll come on to that. But yeah, landscaping conditions are clearly necessary. Protection of existing trees, I wasn't sure about, but there are trees in the vicinity of the site. I saw as much over in towards the estate, so I presume it's those that it's talking about, not trees on the site. Am I right in that, Mr. Henderson?
Sorry, mute myself. Yes, you're correct.
Good.
I think so. That must then mean that the reason is slightly out because it talks about life, but I don't think there's any dispute about what the condition itself is meant to be doing.
No. $25. Yeah, external lighting, including security lights. Yeah, that needs to be carefully handled. I've got no real issues with the way that's worded. We're not in the realm where we need aviation warning lights. I've not seen any reference to that. Sometimes crops up on tall buildings, but I guess that would cover it because it says any proposed external artificial lighting, including security lights. So, okay, I'm probably going down a blind alley. Noise is 26. Yeah, lower than existing background by 10 dBA, as you'd expect. 27, anti-vibration. Okay, that's to isolate plant to stop it transmitting vibration into the building. So internal 28, yes, noise level in rooms shall meet the noise standards in the British Standard. Is that to control any potential impact from external noise, whether it's traffic, air traffic, road traffic, or anything else? I'm assuming that's what's.
Yeah,
that's what
I believe so.
Yeah, because 29.
So I think the wording of 29 needs a little bit of tweaking.
Yeah.
In the first part, I think it should be shall not commence until details have been submitted to.
Yeah.
Tidying up the wording there.
Yeah. So what that's aiming to do is to provide a level of sound insulation between different types of rooms or uses in adjoining dwellings.
I believe it's between the community space and the residential on the uppers.
Yeah.
The only when I was reviewing it just now, just before we came on, it just occurred to me that referring to the different layouts of flats on the 3rd, 4th, and 5th floors. Sorry, 3rd, 4th, and 5th floors. It just occurred to me that there might be some confusion over what the 3rd floor is, because actually you've got ground, then you've got mezzanine, and then you've got what is in effect the 3rd floor.
3rd floor, I see.
So for the avoidance of doubt, I just thought it might be sensible to put in brackets afterwards the floors above the mezzanine floor.
Yes, I think it would want to be clear, wouldn't it? Because otherwise you've got a requirement to add in additional sound insulation where perhaps it's not required.
Correct.
Yeah, I'm if I can leave that with you.
Yes, no problem.
So there's a tweak needed there, a couple of tweaks needed there. So, but yeah, is that, sorry, Mr. Henderson, is that right though? Because 30 deals with, or appears to deal with community floor space separation between community floor space and dwellings. And that requires at least 10 dB above building regs value. So isn't 29 just between bedrooms and a bedroom of one flat, say, and a living space of another flat? So you augment the sound insulation between the two there to prevent transmission between flats, either sideways or up and down.
That seems to be how it's worded. Can I suggest that we take that away?
Yeah.
And make sure we've properly understood the relationship between those two, because I can see that that does appear to be the.
No, you're right.
And 30 is the community space.
Yeah, correct. No, you're right.
Okay. Well, have a look at those by all means. So an air quality dust management plan. So this relates back to the construction process. Because yeah, it's a dusty business. Okay, we haven't got any demolition or any major demolition here, but construction might cause some of that, particularly with concrete. Good. 32. I was. There's a question on the one I've got. Is this condition required as there are no gas boilers?
Yeah, correct. It's all air. Well, it's air source and heat source. So actually, I think it must have just been an overhang from a normal standard condition based on gas-fired boilers, which doesn't apply here.
Mr. Philpott, can you help with that?
I've got two versions of the conditions. The version which contains the query on the CHP and gas boiler condition, and then I have a clean version where that condition has gone altogether.
Right. Okay.
And I had understood from that the clean version reflected essentially agreement with the point that Mr. Henson's just made.
I believe that's correct.
That's very straightforward then. But if after this conversation the clean version can find its way to me, and I'll make that an inquiry document, is probably the easiest way to do it, and then I can refer to that when reporting. Yeah, so 33 is the details of roof enclosures. Okay. So that's what happens. That's what happens on inside the crown, so-called, of the building. Yeah. 34, the access management plan. So you can't occupy or use it until an access management plan has been submitted and approved. A strategy for ongoing consultation with specific interest groups with regard to accessibility of relevant parts of the site. Is that to ensure that anyone with difficulties, who might encounter access difficulties, is catered for in some sort of scheme or plan? I wasn't understanding, because wouldn't that be a requirement of the building regulations anyway?
So I've raised some questions about this just before we started. I'm having to do it obviously remotely, so
yes.
I don't know what the answer is, but I've raised a question about how this works more generally, which goes to I think ultimately to the point you've raised, because what I'm wanting to understand is the end product. Because if one looks at how it's structured, that there has to be a management plan submitted and approved. What that plan has to set out is a strategy for ongoing consultation about accessibility. You then have to carry out the consultation, but then it requires the development to be operated in accordance with the management plan. Well, that at the moment, that only seems to be requiring ongoing consultation and not doing anything with the output from it. So I've raised a query as to quite what it crystallizes into in terms of action that has to then be retained. I don't have a response to that yet, but it seems to me that part of that then will need to include a consideration of how that differs from what you need to achieve by way of building regulation.
Yes, because building regs would require level access, obviously, access to the lifts, and then level access between lifts and doors, and it would cover what happens within some of the flats as well. I'm happy to leave it with you.
We'll talk about that. One of the other things, just for completeness, that I've asked is what's meant by specific interest groups.
Yes.
I appreciate that in one sense one doesn't have to be definitive about that because the plan has to be approved, but it might help, again, give some clarity to the purpose of the condition and what is expected if some examples were given, and that hopefully that discussion will illuminate whether it's more than simply level access, but that's as far as I've been able to take it at the moment. Okay, well, as I say, I'm happy to leave that with you. 35 is lifts. So can't use or occupy until details of fire-rated lifts in each of the buildings have been submitted and approved. Enhanced lift repair services. Okay. The essential purpose of that is to approve the lifts in the first place, and then to ensure that there is something in place to make sure they're running and working properly. See the need for that obviously in a tall building. Now, 36, I wondered about a revised flood risk assessment demonstrating suitable basement waterproofing and floodproofing measures. Is the requirement here that you need to start again with a flood risk assessment, because flood risk assessments are usually sort of things that are front loaded into something, not once you've granted planning permission, because one will be concerned as if planning permission was granted and then there was a condition requiring a revised flood risk assessment, although it does say submit before it commences. So, but what's the requirement here? What it's trying to do? Well, I suspect, I mean, I'm speaking without instructions, but just looking at the subject matter, what it seems to be driving at is not so much an assessment of flood risk as what needs to be done in detail to respond to potential risks. So two particular things, basement waterproofing and floodproofing measures. So I think it may just be that it's slightly inelegantly described. Really a revised flood risk assessment as such. It's details of suitable basement waterproofing and floodproofing measures, and I anticipate that whatever's submitted will need to explain why they're appropriate and adequate. So that's my understanding. That was my feeling. Mr. Henderson, did you want to come in?
Yeah, no, I think that's absolutely correct. I can see it being reworded that details relating to basement waterproofing and floodproofing measures should be submitted, etc. So I agree. I think the flood risk assessment reference is probably a bit of a red herring.
Yeah, good. That's reassuring. Now, 37 is a revised drainage strategy. So, but again, is what is required there a strategy for draining the building? Because I mean, I think this is talking about, well, no, it's talking about foul and surface water drainage, or is it talking about the council having some control about how it takes place? So does it need to be a strategy, or does it just need, like the preceding condition, need
details,
to be details,
isn't it? Yeah, I think it is details.
How it drains.
Details to be submitted and approved.
I suspect that's right. So if not, we can discuss it outside the inquiry and report back to you. I think that's the best way.
38 is window cleaning. Okay, that's about equipment. So details of equipment. So yeah, want some control of that just to make sure it's not visually intrusive or not thought about. But I mean, you don't design a tall building, I don't think, without thinking about cleaning how the windows are clean. But yes, it's right that the council have some control. Yeah, 39. Seen this before. TV interference. So yeah, that's any interference caused by the development to people who already live in the area. So if the building goes up and people have trouble with TV signal, well, there's something in place to deal with that. Yeah. 40. Similar. Airwaves interference study. Is that to do with mobile telecommunications or something like that?
I think it must be. I don't actually know, if I'm being honest. I think it must be.
One of the difficulties, sir, is that the reason makes reference to the previous London plans. I was going to check the policy in the London plan that deals with it, but I think we'll have to check that. Can you leave that with us? So we'll liaise outside and just clarify what the purpose of that is and get the right policy references in.
Yep, I'm happy. Okay. Now, yes, 41. I've not seen this before, but I could understand why it will be done. So the council has to be notified in writing of the full postal addresses of the residential units approved. So it goes to head of development management and quote the planning application number and so on and so forth. Presumably that's to do with parking permit, council tax records. However, okay. I mean, presumably that exercise would have to be gone through with the post office as well, but then there's a delivery.
This is tied specifically to the development control issue of car parking permit. So there may be separate reasons why other bodies, post office has to go through the process, but they're not aimed at this particular issue.
No, that's fine. I think it's clearly reasonable. Yeah. 42. The window glass at ground level in the development shall not be mirrored, painted, or otherwise obscured. Yep, that's to maintain the active frontage. 43, no roller shutters. I mean, I suppose I could argue that they'd probably need planning permission in any event, but I can understand why you'd want to say that. And no adverts. So no neon signs on the outside or on the top without permission. Yeah, okay. So 45, is what I was talking about earlier, replacement planting. Now 46, there's a question as to whether this is necessary.
Yeah, so I think
that's gone. Sorry, I do apologise, Ms. Henderson.
No. I think we were about to say the same thing, that I think we've agreed with the council that matter can be covered by condition 6, which is details of roof, which is rooftop plant details to be submitted.
Okay. (47) So that says no alterations to the external appearance of the building, including the installation of AC, ventilation fans, or extract equipment not shown on the approved drawing. So, yeah, no additional messing about with extracts or fans or anything. Yeah, because I suppose it could be argued they were de minimis and not requiring planning permission. So yeah, cover it. 48. Oh, right, yeah. So there's an issue. This is about external entrance doors not opening over the highway, but some have to because they're fire escape doors.
Well, I think actually it was the original wording was all external entrance doors facing the public highway had to open inwards. But of course, in this particular instance, the area, there is an area around the site that has doors that are facing the highway, but they don't open over the highway, if you see what I mean, because they're within the site. So what we've just done is just change it so that it's all external doors, entrance doors opening over public highways, etc., etc. That then allows the fire doors, which don't open over the public highway, to be allowed.
I see.
Which I think has been agreed with the council as far as we're
okay. Well, is the change that's on here? So take away facing the and putting in opening over.
Correct.
That's sufficient. That's the correction.
Yes, correct.
And so that's reflected in the clean version, which unfortunately you don't have, but you'll have it soon.
Okay, I'll leave it to the clean version. 49. Yeah, PD rights restriction on aerials, antennae, satellite dishes, and so on. Yes, that's clearly necessary. No music emitted from the development, including voices. Yeah, amplified sound. Sorry, emitted from the development. Is that intended to cover the community room, or is it people in the flats as well?
I suspect well, as drafted, it would cover everything.
It would, yeah.
The presence of the community room provides an obvious reason why one would want to have it, but the underlying principle is that neighbouring residents and other noise-sensitive premises shouldn't be disturbed by music or amplified sound, and if that's coming from a flat, it's no less disturbing, I suppose,
Quite,
than if it happens from a community use.
Okay, as long as I'm clear, I'm not. I can see why you would need to do that. Yes, 51. I just wondered about whether this would be a matter covered by the building regs, and one doesn't really want to duplicate, but for a planning reason, accessibility, of course.
Well, again, so I think one of the difficulties is checking this against the current London plan policy, is that if there's a separate development control issue, it seems to arise from policy. And can you leave it with us to?
I'm happy to. Yeah.
Position and come back to you on it. So.
I mean, I can certainly see where you'd want to ensure that, obviously, but it's just a question of whether it needs to be done by condition or whether it is something that you can leave to the building regs. But you know, sometimes planning requirements are different to what the building regs would allow. So yeah, I wouldn't. Well, I think you'd have to be very very strict in order to strike it out on the basis that it can be dealt with by the building regs. But you know, I asked the question. 52 impact piling. Yeah, you want a method statement, and because potentially that is very disturbing. And yeah, there might be things under the site that you don't want to, like water or sewage pipes. So a method statement. Yeah, that makes sense. So yeah, 52. That's it's quite a few conditions, but it's the nature of it. Yeah, it's not the most I've ever seen. So good. That's been very useful. Does anyone have anything to add about conditions?
Not for me, sir. Thank you.
No. Well, it's always useful to go through them, but if you can liaise, you know, tomorrow, Monday, and give me a clean copy when we close on Tuesday, that I think that would be helpful. I'll attach it as an inquiry document, and we can take it from there. let's move on to the obligation. I don't think I need to be very long with this, simply because the SIL compliance schedule that you've put in is very useful, and I can see, you know, you've dealt with it in the correct way. Probably done them before. Yeah, assessed each one against the tests. The only thing I think I need to raise is what was discussed this morning about the public realm and place-based contribution of 50,000, and whether it wouldn't be prudent to ring fence. That, I think that was the term that was used this morning, and we were talking with Mr. Turney about, to make sure it's directed towards place-based specifically, and also place-based within a certain distance of the site. Because I think, I mean, I'd have to think about this very carefully. So I can't say what, I can't tell you now what, you know, what my conclusion might be about this. But I can see just in an advanced look that perhaps one would have to convince oneself that the need that was being generated by the development was being mitigated in some way. And if there's a question about what that 50,000 might be spent on, because it could be spent on public realm improvements rather than play space, there's a question there, isn't there? There's an obvious question there. And also if it could be spent on a play space that was, I don't know, 200-300 meters away or further, again, there's a question mark. Now, it's just something that struck me from reading this SIL compliance schedule and listening to what I heard this morning, and it's been touched on previously in the inquiry. I just wonder whether that might be something that you could have a think about. I don't know. I merely raise it.
We'll certainly think about it. As you'll recall, Mr. Wilson gave evidence as to why he thought the existing more flexible approach was right. So I, until I've had a chance to speak to him and my about it, that's the position in the evidence. But as I put, I hope, fairly to Mr. Turney in cross-examination, if that is the concern, the answer would appear to be to take the approach of ring fencing it in some way to overcome it. So I'll need to take instructions, but and obviously we'll also need to see what the applicant thinks, because it's an agreement. Yeah. But I think the point is understood.
Good. Mr. Simons, did you have anything to say about that, or Mr. Henderson?
I do. It'll actually be, I'll pass over to Mr. White, who I would just like very briefly at this late stage in the day to introduce to the inquiry. My instructing solicitor, Matthew of Herbert Smith's.
Thank you very much. Yes, Matthew White. I'm a partner at Herbert Smith Freehills, and acting for the applicant on this application and negotiation of the Section 106 agreement. And Ms. Rajput is here, who is my opposing, not opposing, counterparty at the council. And yes, we were indeed listening very carefully this morning to the discussion on this issue, and we will take it away. I think we ought to have those discussions before coming back to you. There are a few points in here which, as a result of the evidence and the discussions that have taken place, that we will wish to review. I don't think there will be many changes. That there are a couple that I will highlight to you during the course of this session at a convenient moment, but we will take that specific one away and send you an updated version hopefully on Tuesday.
Okay, well, I mean, really, that was looking at the SIL compliance schedule. There was nothing else that I had that I really wanted to raise about this. I think it's all, you know, you can see why you can say the other aspects of the agreement would meet the tests. It was just that one that was causing me an issue. So if you wanted to go through the other changes that you were thinking about now, I'm content.
Thank you, sir. And I'm afraid they're very boring, but I put them out there simply because you will get a version, as I say, hopefully for Tuesday, which will be redlined. And just to stop you reading it and thinking, why on earth did they do that? I will explain now.
Please.
So, and they're all at the front end of the document, which is not the business end. As I say, it's the technical, boring end. So going through them one by one, just on page 1, paragraph 1.3 refers to the developer having entered into an agreement for sale dated 28th of March. There are in fact 2 agreements for sale, and so we just, which are both noted on the title, and so we're proposing to add in the dates of both, just for completeness there. I should explain the situation that the council does own the site, but these agreements for sale give HFS its interest, which will, conditional on planning, be granted. Secondly, on page 6, at paragraph 4.2, clause 4.2, that at the moment says each covenant in this agreement is a planning obligation. We felt that to be completely clear, it's the covenants in schedules 2 to 7 that are the planning obligations, and those are the covenants that appear in the regulation 122 statement that you've seen. The one exception to that, which has been flagged in the Reg 122 statement, is that the parking compliance, the restriction on applying for a parking permit cannot take effect under section 106 as a result of the Kadari case I'm sure you're familiar with.
Oh, yes.
So we will just clarify that it is with the exception of that covenant, which instead takes effect pursuant to section 16 of the Greater London Council General Powers Act. So we'll make that clear. 11 point, and sorry, that correction to schedules 2 to 7 will appear in various places that you'll see throughout the document. You may have noticed that there is a blue pencil clause.
I did. I'd made a note about that I wanted to raise. Yes.
At paragraph 11.2, which is fairly standard these days for these documents, and I suspect will not be used, but in case it is in there. And then, so just to be clear, clause 5.1, we will say subject to clause 10 and 11.2, which is the blue pencil clause we covenant to comply. And I think that concludes my brief and rather boring contribution to me.
No, that's very helpful. But there was something I wanted to ask about clause 11.2, and forgive me, this might be me, and you by all means correct me because I might have the wrong end of the stick here. But it says if any of the planning obligations contained in schedules 1 to 7 are found by the Secretary of State or the inspector appointed by the Secretary of State for the purposes of this call-in not to comply with regulation 122, they shall be cancelled and shall be deemed to be of no effect. But such cancellation shall not affect the validity or enforceability of the remaining provisions of the agreement. The slight concern I had about that, and I mean, it is probably, me typically sort of reading too much into it, is that there might be a situation where I think something doesn't comply with regulation 122, but the Secretary of State disagrees, because that does happen, and it has happened before. So I just wonder whether you need to, the word, or the inspector appointed by the Secretary of State in brackets would be better off, because I mean it's the Secretary of State's decision. But the Secretary of State usually follows recommendations on those sorts of things, but there are situations sometimes they don't. Secretary of State doesn't. Sometimes the Secretary of State will renegotiate a 106. That happens. So I just want the wording not to trip anybody up if should I think something doesn't comply and the Secretary of State disagrees. But I mean that might be me just being ultra cautious.
No, I think it's a good point. I'm happy to clarify that. The one situation that just slightly concerns me is where you say something about compliance and then the Secretary of State completely ignores it in his decision letter. But I think that's unlikely. So I think we should say that it's the Secretary of State that has the final word.
Yeah, I mean, I think that would work, but I'm happy to leave it with you.
Yeah,
Mr. Philpott?
I think Mr. White must be right about the principle, because if the Secretary of State concludes that an obligation is necessary, and then it is cancelled,
Yes.
we're in difficulties. So we need to make sure that doesn't happen.
Yeah, and that certainly wasn't the intention. So we will make the wording clearer to make that obvious.
Okay, well, I'll leave that with you. I'm content to. We probably or else we'll end up talking about all the different possibilities and combinations, which we shouldn't. Does anyone have anything else about the obligation that they'd want to raise?
Could I just note that, given that I've had an interest in this point about the place-based contribution, it would be good to understand what is in fact going to be proposed before I have to file my closing.
Yes, yeah, that's fair. So if that conversation takes place and when you well, perhaps in advance of certainly in advance of when we resume on Tuesday, because Mr. Turney, you'll be going first. It would be useful for Mr. Turney to have some prior notification of what you intend to do. I think that's fair.
So I think you recall that I'm not in fact going to be with you on Tuesday.
Oh right, sorry.
You contemplated that I'd put in a closing submission in writing on Monday.
I did.
So it would be good to know before then what's being proposed.
Okay.
We will endeavour to reach a conclusion on that. I think today, if we possibly can.
Okay.
But we will let you know as soon as we can.
Okay, and then let Mr. Turney know too. I think that would be useful.
Yeah.
Forgive me, Mr. Turney. Yes, you're not available next week, of course, are you? So yeah, Tuesday then. We'll resume at 10 o'clock. By which time, Mr. Turney, we'll have your closing and it will have been circulated, I take it.
Yes, sir. I don't think you've set a deadline for that, so will you do so?
well, how, I mean, let's talk about how that. I don't want to, it's Friday afternoon and we've had a long week. I don't want to say sort of, well, how does sometime Monday afternoon sound? Is that reasonable?
So that's, I'm fine with it. It's more, I think Mr. Simons and Mr. Philpott should say when in fairness they need to see.
I was going to suggest, bearing in mind the time, and obviously I don't want to put Mr. Turney under undue pressure, but similarly we have to have a chance to look at it and respond. I wondered if 4 p.m. on Monday was fair. It gives Mr. Turney most of the day, but then it gives us a fair opportunity late afternoon, evening to pick up any additional points.
Mr. Simons, are you happy with that?
Some burning of the midnight oil then on Monday. No problem with that. All the better for it. No, 4 p.m. If Mr. Turney's happy with that, that's fine by me.
Mr. Turney?
So if Mr. Simons is okay with it, then yes. But I didn't want to. So we're all going to have a bit of a burden, and I didn't want it to be unfairly distributed. So if he's happy, then 4 o'clock on Monday is fine.
No, I am. I was only joking. 4 o'clock, absolutely fine. Thank you very much.
Okay, and of course, Mr. Turney, if you can finish it earlier and circulate it earlier, then
I won't hold it back. And it may be earlier in the day.
Okay, great. So then on Tuesday, what I'll probably do first thing is if the council gets any contact from interested persons, because I know there was one person who did want to speak who had to leave us because they had an ill relative who hasn't been able to join us again. I will ask first thing whether there are any third parties. So if the council does get any contact today or Monday, then please, through my case officer, let me know and we can accommodate them first. Hopefully, fingers crossed, nothing new that we haven't already foreseen will come up out of that, but I think I'll have to give the opportunity. Then I'll hear from Mr. Philpott, then from Mr. Simons, and then then we'll be closing the inquiry. Talk about the site visit. Mr. Turney, were you available on a week next Tuesday?
So at the moment I'm not, I'm afraid.
Right, okay.
And I was wondering whether you want to deal with that now or whether I should liaise with the other parties and suggest dates where I could be available. The other thing I want to just canvass with you is presumably the desire to have me there is so that there is an objector.
Yes. Yeah, I mean, I think, we've, it is one part of it, yes. Yeah, but I'd also want to be sure that I went to all the places that you would want me to go to. That's the other part of it.
The brief conversation I had at lunchtime, and I just test this with you to see if this would still be satisfactory, was whether if I can't offer much by way of availability, whether if my wife, who has objected, accompanies you, whether that would still be satisfactory. And I can tell the other parties in advance where I think you should go. I just wanted to test that because I don't want to hold things up because of my diary problems.
Well, I think yes, that would be it. I think it is procedurally better if I'm accompanied. If it's an accompanied site visit, I need to be accompanied by both sides, I think, in one way, shape, or form. And if there's an itinerary that we can all work to and that we can follow, I think that's always useful too, rather than doing it in an unfocused way. So yes, if you can talk amongst yourselves about the best way to do it, where I need to walk, where I need to look from, where we need to take visuals into account. But if there is a day apart from Tuesday that week, because I don't have anything in my diary that week. It's just that Tuesday was the day that suited me best. So Wednesday or Thursday. Friday I'd rather avoid, and Monday's never great. So any Tuesday, Wednesday, Thursday that week. But if it's not possible that week, then so be it. But I think then we'd be into the new year, and it's always good to do the site visit when everything is fresh in your mind. Obviously, you understand that. So
I'll contact the other parties once I've looked at my diary, and hopefully between us we can suggest a date and B, a broad itinerary. Great.
Can I leave that with you then? Good. That's helpful. Okay. Well, in which case I'll see some of you on Tuesday. I hope you all have a good weekend, and please, Mr. Philpott, do pass on my best wishes to your poor witnesses who've come down with it. I hope both are on the road to recovery. But yes, until Tuesday then. Thank you very much, everyone.
Mr. White's just got his.
Yeah, sorry. I should
Mr.
have
White.
just said, since we're on the obligations, would it be acceptable to you if we were allowed a period of 2 weeks following closing for the obligation to be completed?
Yes, I'll have no problem with that. But we can confirm that on Tuesday. I'll talk about, what the progress will be with the report on Tuesday, probably when my deadline will be for submission and so on. So as long as,
Thank you.
And I recognise that 2 weeks will probably be Christmas Day or something. So that's not reasonable. So we might need to extend this a little bit. I'm content with that.
Thanks,
good. Okay, well, thanks everyone. I'll see some of you on Tuesday, but thank you, Mr. Turney.
Thank you very much, sir. Thank you for hearing me.
Thank you.